Under an exceptional circumstances, may I be permitted to mention item number 347 and 348?
I'm sorry, sir. I'm not taking up mentionings now. Please wait for some time.
Not only
Under some urgency,
What is your urgency?
I have been given the lease from the Zera Porishad from the ADLRO to do pisciculture in 2 ponds. In 1 pond, they have not given me the settlement. They have accepted the lease rent and I'm doing pisciculture. The difficulty is, in 1 pond, the ADM has directed the local police to provide police protection. Now, in my pond, that order is not there. Now, the police is saying, as writ petition is pending before the court, we cannot provide you any protection. Now,
wait for some time.
My features are looted by the locals. I cannot enter into the area.
Please wait for some time.
My matter was mentioned and fixed by your lordship some time back as the first hearing matter. It was appearing as the first hearing matter. Now it was adjourned for 2 weeks for filing one affidavit. Now it has gone down to the bottom of the matter.
Please wait. I'm not picking up mentionings now. You're aware.
It was already allowed. Before the embargo, it was allowed by your lordship.
Cases like this, please wait. Yes,
Lord,
call the
correction, my lord.
Upon notice.
Upon notice, no. Notice.
Number 1. Yes.
I'm for the petitioner. Please release this matter.
You don't want to proceed with the matter?
No.
Or is it under some other determination? What are you asking for?
It is for releasing of the matter.
Releasing on what ground?
Your lordship is overburdened with this matter. Let me try
Yes.
some other. The lordship is overburdened in this way. Let me try in another way. I have mentioned on several occasions. There's a direction to list this matter on 9th of January. I have mentioned on several counts after that.
Then counsel for the petitioner seeks release of the matter. Paragraph, the matter be released.
Kindly don't take me amiss. I am on instruction to see.
Absolutely fine.
Wait.
Next.
Lordship, I am for the petitioner. This is the restoration application.
Have you served the respondents?
Yes.
But I am appearing for HITCO, my lord. Mr. Deis for the state.
Restoration application.
Kindly allow me.
Why have you filed 3 applications? Scan?
Straight from the
Same prayer in all the applications. Let it be restored, Mr. Day. Let it be restored. Can 1 of 2024. Actually, I couldn't সবগুলো can 1 of 2024. Copy আছে অনেক। Huh? কিছু কি সব 1 of 2024. সবকটা same number. আলাদা কি? This is an application for restoration of the writ petitions which were dismissed for default by an order passed on 5th February 2024. Paragraph, sufficient grounds being made out, comma, the applications, these are applications. Sure. The applications are allowed. Paragraph, the writ petitions being WPA shorter number be restored to their original files and numbers. Paragraph, the applications are disposed of. But WPA, ওইগুলোতে করি। Let it appear as a motion.
My lord, the pleadings are complete. My lord, the matters were lastly appearing under the heading hearing, my lord.
It's appearing as a hearing matter.
My lord.
দুটো আসেনি একটা পেপার বুক হয়ে আছে ওইটার উপরে হিয়ারিংটা চলছিল এগুলো সব অ্যানালগ
আচ্ছা, আসুক।
হ্যাঁ ওই জন্য অর্ডার
Affidavits on record.
My lord, we have exchanged the affidavits, my lord. My lord, we shall be filing the affidavits, my lord. My lord, but the matter was kept under the heading hearing, my lord.
I do not find that also on record. Anyway, I'll fix it on. Let the matter appear under the heading Group 1 hearing. WPA with order. Let these matters appear under the heading Group 1 hearing on 20th May.
Grateful. 20.
স্টেট আপনাদের
Next.
Contempt for the petitioner.
শোনা যাচ্ছে না এদিকে। একটু জোরে বলবেন। Yes.
For the petition, my client has already received the payment, Lordship.
So it is complied. It is Mr. Day is appearing. It is complied. It is submitted on behalf of both the parties that the order under contempt has been complied with. Paragraph, in view of the above, the contempt application being CPN such and such is disposed of. There shall, however, be no arrest to costs as been certified website. Next.
My lord, your lordship will take the complaint.
This is the affidavit.
Yes, my lord.
আগেরটা
এইটাই
Kashu,
যেটাই অর্ডার হচ্ছে
the affidavit of compliance
Affidavit of
submitted on behalf of the alleged contender is taken on.
এটা দেখে দাও
Affidavit of
করেছি যখন
compliance
একটা
submitted on behalf of the
My lord,
alleged
this
contender
matter,
is
my
taken
lord,
on.
I undertake that with the court appeal that money will be paid.
So it has been done. It has been given.
এটা पहले
Item number 9.
9 I'm for the petitioner. Lords, kindly see the last order, the contempt application, and also the order dated 8th February
The
2000.
acquisition map, yes.
My lord, received one instruction and which, my lord, acquisition map, my lord.
You have the acquisition map?
Yes, my lord. One, there are two LAKs, my lord. By way of two LAKs, the land has been, a part of the land has been acquired. We can, my lord, obtain one, my lord, LA map, my lord. That is also my third condition, my lord, wherefrom it appears that some middle portion of the plot in question has been, my lord, acquired. But your lordship may direct, my lord, the land acquisition authority to demarcate in the presence of the, my lord, the head court and the petitioner.
That was the direction.
That is the direction of the BLR. BLR is not, my lord, it's not, my lord, able to, my lord, demarcate the land, my lord, because
The original order.
Let him also be
That's
there
what
and
he
let
said.
the land acquisition collector also go. It is the state's obligation. We will, my lord, as HITCO also be there.
That is, the order is there. And it's a PCA, when kindly see PC.
Separate order is required to be passed. Because everything is stated.
Very well.
Only for passing the time.
My lord,
Nothing.
kindly, my lord,
Because demarcation will not be done by the special land acquisition officer.
yes,
It
it
has to
is
be done by the BLR.
correct, my lord. So he has to be there.
Special land officer has also to, my lord, expert, my lord, this was subject paragraph 7 of my report, my lord.
আছে কপি আছে আমাকে দাও না।
Furthermore, it is humble submission to the honorable court to issue direction upon the land action department not responsible and authorities of West Bengal Housing Corporation for a joint inquiry to demarcate the land of the presence of all the interested parties along with the requisition.
Have you seen these instructions?
Sir, I, my lord, can't understand why state must, one department of the state must ask the court to issue a direction on the other department.
You are representing all of them.
Because my dealer is not, my lord, yes,
My lord, I'll tell you, lordship, the my lord, practical difficulty, my lord, if the BLRO, my lord, indicates that he needs the assistance of the land acquisition collector, he is no one to, my lord, request the land acquisition collector to go. either it has to be, my lord, from the court, my lord, from either the government pleader or the advocate general, or, my lord, if your lordship directs, then it can, I understand the practical difficulty, but anyway, before court, this is not proper.
Your lordship,
It is
direction
a,
is clear.
it is a practical difficulty, that I accept. Having gone through this myself for some time.
Will not be able to get the all the LA map. That is why I am submitting your lordship direction issued on the land acquisition department, and evaluation may be done in the presence of the equal. They are again asking for land acquisition map.
অনির্বাণদাকে বলো না বলতে।
So let me let me direct the special land acquisition officer in terms of this
Yes, yes.
and on the basis of submission made by learned counsel. Yes,
I have not received any instruction or any.
please have a copy. Mr. Maite, do you want to go through this and come back, or shall I pass an order?
Lordship passed no order. Lordship feed. Lordship is enough. I can say. Lordship is enough.
Same thing,
Lordship's
both
order
land
is
and
still
property.
clear. The authority can sitting idle about this. When the problem is created, the authority can solve this matter.
That point. But the
Go and tell him.
petitioner is not been able to assist the
How the petitioner will have with the authority?
My lord,
Petitioner, how can say?
petitioner, my lord, has purchased by a deed.
Yes.
Now, third parties are either government or third parties are in possession. In all probability, my lord, either he'll have to get it from me, or, my lord, it will be acquired land, or it will be third party, he'll have to file a suit.
Petitioner is not in a position to assist at all.
Petitioner is not in a position.
But the things for a woman for the very outset, Malay stated that the
Point
land
is,
has
my
been
lord,
kind of the
ultimately petitioner
encroached
will,
by the
ultimately, my lord, by this way, he'll have figure out, my lord, who he has to go against. And if it's, my lord, in the possession of the state and it's, my lord, then we'll have to give him possession.
Let the special land acquisition officer do it.
Yes, yes. Let him do it, my lord, expeditiously.
some time.
what's time? It is the contempt
Time is being
application.
given, in fact.
Demarcation has been done, my well.
Given by some time.
They are going to demarcate my fortnight.
It is the contempt application.
And the next submission which is coming is election.
That is the next one. That is the next one.
Report submitted on behalf of the second alleged contender is taken on record. Paragraph heard learned counsels for the parties. Paragraph. It is submitted on behalf of the second alleged contender that the land acquisition paragraph 7 means nothing. Direction upon the land acquisition department, not 24 Parganas, to hold inquiry.
This is the first land acquisition collector.
That is how choice for it.
Kindly direct the land acquisition of
Not so this one.
not Chobbish Pargana.
So the land acquisition department, not 24 Parganas, will be directed. The entire department.
Collector,
Land acquisition officer.
land acquisition officer, the head of that department.
Should be the special land acquisition officer in that case.
Spells.
Submits that the Petwala. That the special land acquisition officer, comma, North 24 Parganas, be directed to hold joint inquiry and demarcation of the land of the petitioner and the authorities of HIDCO also, that is also added here, along with the HIDCO authorities in terms of the order passed by this court on 10th February 2023 in WPA 17082 of 2022, bracketed order under contempt.
And also in the contempt application, further direction was also there.
That is the order under contempt.
is-
That has to be complied with. Paragraph in view of the above, the special land acquisition officer, comma, North 24 Parganas is directed to hold joint inquiry of the land in question and demarcate the same with the HIDCO authorities in presence of all the interested persons in presence of all concerned, including the petitioner.
Lord, the only one thing, my lord, may I suggest? Lord, the whole thing's problem is created. Lord, as per the LF map has not been clear. That is today I come before lordships. Other day, another person come before the lordships. This is going on. Lord, the whole things will be completed in terms of the Moja map and the LA, my lord, the proceedings. Otherwise, the matter cannot be.
See, the other special land acquisition officer wants to do it himself. Let us see.
We shall
And
demarcate
submit a report on the adjourned date. Yes?
demarcate the acquired portion of the land.
No, no,
course.
petitioner's land.
No,
Not
why
the
the-
petitioner
Not the
land.
petitioner's land. They have to demarcate the acquired portion.
Actual portion.
No, but your lordship has said the land in question.
They cannot, land in question is the acquired portion of the land. And they want to demarcate the land of the petitioner.
Of course, it will be evident.
If that portion is demarcated, we'll see, we can find out.
And would
the
your
other
lordship be
portions.
pleased to, my lord, direct both the petitioner's land and the acquired portion of the land? Then we'll know where it is.
This land cannot be demarcated by the authority. It's a private land. Let the acquired part be demarcated.
No, but Lord, we're not on physical demarcation, because physical demarcation may or may not be possible. But if, for example, it's acquired land and it's been given to a government department who has done something else, then there's no question of physical demarcation. It will be a notional demarcation. He'll be shown, and that will be the end of the matter. We'll ask for
There should be
dismissal.
it's taken. It has to be done physically.
Yes,
How,
if it,
how can there be a notional
it,
demarcation?
it might be right in the middle of something else. So in that case, my lord, there'll be no physical demarcation done.
This is
There should be a boundary of the
My lord,
acquired
may,
portion.
may I, my lord, say this? There is a distinct possibility that, my lord, the petitioner's land will be either a part of some other person's privately acquired land, or, my lord, land which is acquired by the state. If it is land which is acquired by the state, petitioner will have no right. His writ petition will be dismissed. If it's, my lord, land which is within third parties, my lord, private parties' land, then also, my lord, he'll have to go and agitate there.
That's a different.
So in those circumstances, there is no question of a physical demarcation. However, my lord, if it is not either of the two, then there will be a physical demarcation.
Let us see.
That
because
is that
you
is,
will also be present there. Your authority
yes,
will
yes,
be there.
that is why.
The petitioner will be there. So let us see what.
Yes,
happens.
yes, that is why.
When will you come back? I'll let the matter appear under the same heading on 15th May.
Grateful, my lord.
Next.
Item number 10.
Lordship, I am for the state respondent. We have Lordship asked for the be allowed for demarcation. Lordship, demarcation is processing is going on. Lordship, can Lordship grant me some more time? Lordship, we will comply the Lordship order immediately after receiving the demarcation report. Lordship.
Demarcation ought to have been done earlier. This is a 10-4 order.
Because Lordship difficulty is
The
that
proceeding was initiated upon demarcation.
Lordship difficulty is that in another you also directed us to comply the order of the district magistrate of 11
Yes,
January
I'm
2023, Lordship.
Yes.
But the same order was set aside by your Lordship in another proceeding, order of the DM, Lordship. I have a copy of this application. Can you, Lordship, have a look?
Number 3.
It was a, how can it be the same order?
Our case, Dag number 29 and 30.
That was the difficulty in we confused what we will do. In other, this is another portion, Lordship. In the W2 PA 2168, Lordship. Second page, Lordship. Can you see third paragraph. Accordingly, the order issued by the district magistrate, Purbo Medipur, 11 January 2023 is set aside. That's why we confuse what we will do. If we are going to proceed, then he will come before Lordship with contempt application.
This is not
No,
the same petitioner.
Not same application. In this another application, the entire order of the DM is set aside by your Lordship. In spite of that, we are taking steps, Lordship. We are under proceeding, Lordship. We will comply your Lordship order.
Yes, because this is a different petitioner altogether.
The order was same.
This was not brought to the notice
No,
of the court.
Yes, Lordship.
That there are other petitioners also.
Lordship.
That was not brought to the notice of the
Lordship.
court, isn't it?
Can Lordship give me some more time, Lordship?
Yes, one month.
Lordship.
Election.
Lordship.
One problem, because our tag number 29 and 30, but wrongly include 30 and 3 in the order. এই orderটার মধ্যে
There is 30 and 3 included.
page number 68. That number is 30 and 29, but in this case,
68
include 3. Therefore,
নিচে
bottom portion of the first page. Order 68 page, my lords, order 68 page.
Yes, it is 30 and 3, but this cannot be corrected at this stage, isn't it? So let them comply. Let us see. The learned advocate for learned counsel for the alleged contemptor
Minor mistake.
seeks accommodation to comply with the order under contempt. Paragraph in view of the above, it can be view of the above. Let the matter appear under the same heading on.
Lordship, you can't some more time because of Lordship, I do not want to say because of the election procedures in which district and which constituency.
Moment private respondent making construction
That has to be demolished.
and the authority concern
17th May.
17 May. 17 May.
এইটা তুমি একটু
আমি
Next.
item 11
সেটা কাগজটা যদি কেন লাগে
item 11 ওটা একটা কপি স্যার রেখে
You can take this back.
ওইটা দিয়ে দিন
এটা ফেরত দিন।
Well, it is a new contempt, my lord.
So please serve and come.
Yes, but I have to serve first.
The applicant petitioner is directed to serve copy of the contempt application along with annexure thereto upon the alleged contemptor and file affidavit of service on the adjourned date. Paragraph, let the matter appear under the same heading on 14th May.
I'm grateful, madam.
Next.
But 12 in this matter, I am praying only for not to do on behalf of Mr. Samanta. He's on legs, my lord. Only for not to do, my lord.
The sand mining policy has been challenged.
Actually, I am not brief, my lord.
It
I'm
will
just.
not, I'll give a date. I'll just. No. Subsequently, he has said that he has challenged the applicability of the policy, not the policy. He says it is not applicable in his case.
Coordinate page that has been rejected by my lord Mr. Samanta while taking up judgment matters. That order has not been agreed. So as on date, the right to challenge the applicability of the validity is still there. So I would like to bring on record that judgment.
Well, are affidavits necessary? Why don't you come back with a report if you want to?
Yes.
Yes.
Yes, sir.
So that matter may not be delayed further. It comes
Because on the earlier date, you submitted that you do not want to file a report.
possibly
That is recorded.
Actually, not that the earlier date, but current we are saying
No. They are challenging the applicability of the notification in this matter. Not the virus of the notification.
the report.
So shall I just adjourn the matter today?
Yes. Yes, ma'am.
On prayer of the petitioner, the matter is adjourned.
Not the private respondent, so I will not be able to.
Why do you want to file opposition?
Actually, Lordship, there are the some suppressions of facts, so I want to.
There are a series of litigation partners. These was granted by the government in favor of the private respondent. There was a partnership agreement between the petitioner and the private respondent. Due to the dispute amongst them for a considerable period, the filing activity was stopped. That was the ground for extension. This honorable court referred the matter in terms of the appeal was made from the judicial commission of the aspect has rejected the appeal, challenging the order of the other appeal as well as challenging the applicability of some kind of policy is present in judicial. So there are certain things which are not been disclosed.
Let there be a direction for affidavits in that case.
My lord, kindly make it not today, and then I am not petitioner, my lord. My lord, without not affidavit means
When he is asking for affidavits, the court has to allow. Otherwise, that will be the ground for appeal. Very well. Learned counsel for the petitioner seeks petitioner নেই এখানে, কেটে দিন। An accommodation is sought on behalf of the petitioner. Paragraph, learned counsel, you're 8 to 11.
8, 9, 10.
Learned counsel for respondent numbers 8 to 11 seeks to use an affidavit in opposition in this matter. Paragraph, affidavit in opposition be filed within 2 weeks. Within 2 weeks from date, stop affidavit in reply, comma, if any comma be filed within a week thereafter. Paragraph, let the matter go out of list for the time being, liberty to mention. Next.
Listen.
Item number 30.
I'm getting for the petition, my lord.
Yes.
We had used a supplementary affidavit. Thereafter, my lord, objection has been filed by them. And my lord, we have also filed a rejoinder to that objection.
Never ending process.
Yes, my lord, it has been done, of course, after now.
Rejoinder to the objection again.
I don't know why they are denying, because these are all documents, my lord. Inadvertently, the stay application was annexed without annexures. So we had to file the supplementary affidavit and some orders passed by the first authority. Those are also to be annexed. And the original lease deed.
Have you served a copy? I find the copies are also here.
We received. We are the private.
You received. These are the copies.
কপিটা চলে গেছে,
Yes. So are we ready for the hearing then today?
Well, your lordship will kindly fix a date, my lord. We'll continue with the hearing.
Rejoinder used by the petitioner to the objection filed by respondent numbers 4 and 5 is taken on record. By consent of the parties, adjournment. Paragraph, by consent of the parties, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th May.
20th May, nearing the vacation.
I have a circuit bench in between. Yes.
My name perhaps does not go very correctly to the order. But for the last matter,
Give your
oblige.
Next.
I'm for the petition.
Item number 14.
The joint inquiry has been held.
My lord, no copy has been served as yet, my lord. Order passed on 10th of January, my lord. 2 occasions they sought for time for submitting the report, but till date no copy has been served. So we would not file the exception as well.
Have you served a copy?
Just
You want
here,
to use an exception to this?
my lord, let me go through it.
If required,
if required, then we will file.
I'll grant you liberty.
My lord, my liberty was also already granted on the earlier occasion.
Very well, very. Yes, it's granted. You should have served an advance copy. Report submitted by the state respondents is taken on record. Paragraph copy of the report is made over to learned counsel for the petitioners in court this day. Paragraph on prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th May.
My lord, yes, grateful, my lord.
Item number 15.
I picked up for the petitioner. This case arises out of a metro railway acquisition, where the complaint authority has awarded a sum of rupees not 2,60,000 per kata. In appeal, it was enhanced to 3,06,000 and odd. On the basis of a document produced same motion, another deed was produced. The authority did not consider the interest component. There are two sections. Section 80 of the 2013 Act, which applies, where they have taken possession from that date, I will get interest. And under the Metro Railway Act also, there is a provision that they have to immediately, on award of the complaint authority, they have to deposit immediately. If they don't deposit, then a 6% interest is there. They did not deposit, in execution they have paid. So these are the two grounds on which I am challenging. The ground of my challenge, and Metro
you are the petitioner.
I am the petitioner. I am for the petitioner whose land has been taken. The authorities they have also challenged the order of the appellate authority. But I say their matter has I say their matter has become infructuous because the decree has been executed. Entire amount has been paid in execution. But anyway, let them place. Yes, disbursed. Everything is disbursed. Yes,
received the money. Not yet been disbursed.
No, disbursed. I know.
For the metro. In the next matter. But it has been executed as Mr. Banerjee submitted.
We have received the money, case disposed of. Okay, execution case, my friend appeared there, my lord, it has been paid and disposed of.
You've received the money and it has been disposed of.
Yes. So far as the amount I've already awarded. I pray.
And now you're only on the interest.
Only on interest part.
I will find seconds of that. They have also received the money. Now, procedural or 12, the officer guided.
I have instruction. So let me.
No, there is no question of withdrawing. It will be disposed of as redundant. No, nothing further remains in it, isn't it? Do you want to come back with instructions? What was the prayer? What's the prayer in the second matter?
Second, they have challenged the valuation of the complaint authority, appellate authority on the ground that IGR has given a valuation which is much lower. So they rely on the report of the IGR. I say that the deed will prevail because it is higher.
The reference deed because it was talking about a plot of land. The plot is not within the vicinity of the subject land. It is way but beyond and it is beside metal.
That has been considered and a matter has been, the execution has been done.
That is the thing on this.
And the amount has been paid by you.
I understand.
So after you pay the amount,
let me come back.
Let her come back.
I know for sure, but let her not take the instruction. That is the paper possession. Our case is that I'll just not point out.
The earlier matter is only on the interest part.
Interest.
Interest, the data possession. My case submission.
12th February 2022.
I'll clarify. I clarify. What is the point? I have taken the point that immediately on vesting, Metro Railway entered into my land utilize the land and put up their boards. I have annexed the photographs. They say they admitted in the report that we have installed the board, but that is not taking over possession unless formally it is taken over. That is their report.
So how can you affix the board before taking possession? So you are affixing the board in someone else's land because you have not taken possession?
And look at page 61. What is the board?
Please come back because she is not ready to. That is already on record.
I've read it.
Should be on record.
On vesting, I say.
Please come back.
That the matter was last taken up on the 3rd of March.
1st of March, yes.
1st of March, but the order is not available. Last order available is not January, but the last order.
Ashu, নাম্বারটা নোট করুন, দেখুন তো অম্লানের করে সার্ভার হয়নি বলছি 1st মার্চের অর্ডার একটা নোট করুন, সার্ভার হয়নি বলছি।
Yes,
Let there be no further extension.
My lord,
I'm not extending it.
bow down to that, my lord.
I'm not extending because
Municipal money has been paid. I bow down to
yes,
that.
yes,
Only
it
with
is
the possession has
almost
been
over. Yes.
My lord.
It is submitted on behalf of the petitioner. You're the Metro Railways and the Metro Railways Authority in WPA 18143 of 2023. That's the first matter. That the principal amount of compensation has been received by the petitioner. The petitioner seeks interest on the said amount. Stop. Paragraph. Learned Counsel for the Metro Railways in WPA 19775 of 2023 seeks accommodation to take necessary instructions in this regard. Paragraph. Let the matters appear under the same heading on 16th May.
So that not possible.
You can come back on 6th is monthly list, 7th May.
7th, much of that.
Since it can be disposed of.
Now the point has been.
It is not being extended. That's sufficient.
Yes.
No need to record that it is not extended, isn't it?
Fine.
A negative recording is not necessary.
Much obliged.
7th May. Next.
Item number 17.
15. Oh, এটা 15, 16 হয়ে গেল না?
What happened to the
Yes, you wanted to use an exception.
Yes, my lord.
Are you using an exception to the report?
I have not yet filed when I said the exception record. The other day, I submitted before this petition in judgment. I can file
You want to file?
Yes, I can file it. I have it.
Please.
I have seen.
Please.
Because the low compensation has been paid, possession was taken. Now, following the inter-development decision, there. When I obtained it, that the division judge in my case, my lord, that I want to submit that, cite that judgment, my lord. But I want to file a report to the exception.
So please
Exception
come
to the
back.
report.
Please
Yes.
come back. Learned Counsel for the petitioners seeks extension of time to use the exception as sought. Paragraph. Let the matter appear under the same heading on 13th May.
13th May. May I submit the division judgment? I want to cite this judgment.
Annex it to your exception.
Oh,
If you submit it like it might get misplaced, please.
I shall annex a copy of the
Yes,
judgment.
yes.
13th May. Thank
Please serve an advance copy so that we can deal
Yes,
with the
I can-
matter.
Item number 18.
you.
Yes, anyone? No, anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Dismiss for default. Next.
I am appearing for
I'm appealing for the state, my lord.
Yes, you are the petitioner.
I'm your lordship, who can amendable Lord see, set up a statue of Sidhu and Kanu at Nadam Mode within police station, Gurab district, Hooghly. Against that dismissed. Against that program, Lord, the one Manik Soren, he filed filed a written objection and thereafter filed a writ petition. And that writ petition was heard with your lordship, Lord, and your lordship was pleased to pass order, that is at page number 21. Lordship was pleased to pass and directed the SDO to consider the objection and pass a reasoned order. And the concerned is SDO, that is SDO Sodor Hooghly, passed order, also passed order and allowed the petitioner to set up statue of Sidhu and Kanu at a place, but subject to consultation and permission from the respondent authorities of respondent number 10, that is Indian Oil Corporation, because there was a underground
Underneath pipeline and my lord, pipeline and
Let him complete, please.
and thereafter, Lord, relevant portion, Lord, I am reading from the order.
At page,
That is at page number 28. On the other hand, the highway authority can grant permission under section 8, subsection 2 of the West Bengal Highway Act 1964, having due regard to the safety and convenience of the traffic and subject to the condition as may be prescribed. In the present case, the Hooghly Highway Division may take into consideration the right of ingress and egress of Manik Soren and the presence of gas pipeline underneath. But thereafter, we visited the office of the respondent, my lord, and all the respondents orally submitted up the statute in a space.
so you were the private respondent in the earlier matter.
Yes, ma'am. In the earlier. And lastly, I made a representation that is at page number 30. And it's at P6. That is page number. Yes, page number 30.
30.
30. So just my prayer to your lordship is to give us permission in written that we can set up the statue of Sidhu and Kanu, considering the safety, security, and traffic, and as well as the distance, minimum distance from the pipeline. That can be decided by the respondent authorities of the IOC, Lord, Indian Oil Company. That is my prayer.
my lord, this is the instruction, my lord. Can you see, my lord? Or in terms of the order passed by this honorable court, my lord.
Have you served a copy to the petitioner?
No, my lord.
You have to serve a copy.
Yes, my lord, I am giving, my lord. Kindly come to page 8, my lord, of the order, my lord, passed by the sub-divisional official.
Yes, this is the same order that is annexed to the writ petition.
Yes, my lord. If, my lord, permission is granted, my lord, there is every chance to make any incident, my lord, because under the need, my lord, there is pipeline and mineral water line, my lord, and my lord, traffic system will be, my lord, disturbed, my lord, very much, my lord. Kindly come to page 12, my lord.
Why don't
Of
you
that
decide?
order.
Because you have not turned down the prayer. In this order, you have not rejected the prayer.
My lord, yes, my lord, upon the observation, my lord, the petition of the representation of the petitioner, my lord, has earlier petitioner, my lord, has been disposed of, my lord.
Has been
It's
disposed
14
of
months.
with
Yes,
certain observations.
yes, my lord, with
You have
certain
not
observation.
stated in the order that the statue cannot be put up. There is no observation in the order. Only certain facts are stated.
Yes, my lord, but observation is that, my lord, kindly, my lord,
On the other
consider.
hand, you have stated that the petitioner of the earlier petition
Yes,
has right only for his egress and ingress,
Yes,
nothing more.
Yes, my lord.
So you have not rejected the
That
prayer
has-
of the
That has
private
been
respondent.
settled, man. He has not filed any objection and or filed any writ petition against the order. That means he has accepted the order. Now, in Indian Oil Corporation,
My lord,
Please take the microphone. Switch it on, please. Your voice is.
আবার off হয়ে গেছে। হয়েছে।
Yes, my lord. My lord, I'm appealing for the respondent number 10, my lord. My lord, the statue which is proposed to be, my lord, set up, my lord, on the land of the PWD, my lord. But in section 9 of the, my lord, Petroleum Mineral Pipeline Acquisition of Right or User of Land Act 1962, my lord, there is some restrictions, my lord, that to construct any structure on the land, my lord, under which any pipeline has been laid, my lord. So, my lord, if, my lord, no pipeline has been laid, my lord, in the land where the statue is proposed to be set up, my lord, then the IOCL authorities have had no objection, my lord. But,
So
my
I
lord, it
refer to
has to be
submission.
ascertained, my lord, whether there is any pipeline has been laid or not, my lord.
You want to ascertain?
If your lordship direct, my lord, then if there is no such pipeline, my lord, the Indian oil authorities have no objection, my lord, to
There
set
is
up that
pipeline,
setup.
my lord.
No, my lord,
It is, my lord, from the
that
report, my lord, it
document-
is clear, my
that
lord.
orally, the authorities of Indian Oil Corporation assured us that you set up the statue, just giving just leaving some distance, 10 foot or 8 foot distance, and that is there.
My lord, oral
And
submission, how it can
No,
be
no,
accepted
no,
unless and until, my lord, order is passed, my lord.
Well, they may survey the very
My inquiry
claim.
has been made, my lord.
Where is the inquiry report?
Inquiry report, my lord, in the order, my lord, it is, my lord, depicted. Kindly come to page 8, my lord.
Page?
Page. Page 12, my lord.
Page 12, my lord.
Yes.
The assistant engineer further states that there is a pipeline of Indian Oil Corporation
Here to the center.
passing underneath the portion of the plot number structure, and therefore any construction shall be regulated by the provisions
No physical inquiry has been made.
of the petroleum
That
and
is the
the
problem.
mineral water pipeline
We
is
shall
there, my lord.
keep, we shall
Where is the physical inquiry held by you? How did the assistant engineer say this? Just without any inquiry? Yes. It is just a statement made by the assistant engineer. On what basis has this statement been made?
Yes, my lord, had submitted a report, my lord, to the executive engineer Hooghly. This is the, my lord, instruction, my lord.
There should have been a physical inquiry. Where is that inquiry
My
report?
lord, kindly adjourn this matter so that I may come with the physical report, my lord, of the assistant engineer of Hooghly, my lord.
Let them come. I
Uh,
would request
Your lordship,
physical
kindly-
inquiry, my lord,
counsel
has
also
been
to
made,
come
my
back
lord.
with the report. stating what all you have just submitted.
Physical inspection report, my lord.
Physical inspection report, or you've just submitted that if it is beyond the
As your lordship.
portion of the land where there
Yes.
is the pipeline, you have no objection. Right?
But,
So please
I am
come back
submitting
by
one
way
thing,
of
Lord.
affidavit with that,
The
yes.
order has been passed by the subdivisional officer in presence of the executive engineer. So executive engineer had no objection. That has been
This
recorded.
is, where is it recorded? It is not recorded. Executive engineer has no objection, that is not recorded. They say if there is no pipeline in that portion, you can do it. So
So question is pipeline.
there should be a physical inquiry.
Yes, I have no objection. I have no objection regarding physical inquiry.
And learned counsel says that there has been a physical inquiry.
Yes,
right?
my lord. Yes, my lord.
Yes, physical inquiry. There was physical inquiry and executive representative of the executive engineer was present at the time of
Yes.
hearing.
Yes.
With the subdivisional officer. Now the only problem is Indian Oil Corporation. They may submit a report. If there are sufficient space for setting up the living some distance.
Because in this order, there is nothing. No specific observation has been made in the order. It is a very vague order. This can be done, that can be done. This cannot be an order of an authority.
Now, there is no.
Let the
Ma'am,
respondents
sorry.
come back with a report.
Yes, I have no problem.
Let them come back with
My
a
lord, on
With the definite-
20th September 2022, my lord, the BLRO, my lord, submitted the inspection report. Therefore, my lord, physical report has been made, my lord. Kindly,
The report should demonstrate
yes, my lord, physical
in
report,
which
my lord.
part of the land the
Land, yes, my
pipelines
lord.
are there.
Yes, my lord.
Yes, please come back with such
Yes, my
report.
lord. Yes, my lord.
We are also agree that pipeline should be, a distance should be left between the pipeline.
My
Let
lord,
that
from his submission, it is also clear that, my lord, under the name, my lord,
Yes,
there is a
therefore I have
pipeline.
in a portion of the land.
Yes, my lord.
Not
There are
under the
sufficient
entire land.
space.
Yes,
That is my
And the authority says that if it is constructed beyond that portion, they have no objection.
Yes, my lord.
So do you have objection if it is constructed beyond the portion where pipelines are laid?
My lord, kindly let me come with the report, physical report first, thereafter, my lord,
Let her come.
we are coming.
Instructions submitted on behalf of the state respondents is taken on record. Tarag affidavit of service.
এই যে report দিয়েছে, এই যে, এই copy টা।
The petitioners seek to
এই যে,
erect a statue of Sidhu and Kanu, comma, leaders of Santhal rebellion in a portion of where do you want to erect the plot number?
That is on PWD land with permission.
Plot number?
Lot number, my lord.
Specification of the land.
It is not in your writ petition.
That is
Lot number 3186.
Where is it stated in the writ petition?
My lord, at page 24, my lord, from order sheet.
From the order
appears.
In the writ
not
petition,
page 5 minutes. Page 5 section para 4. Last
Yes.
line. Khutian number 1417 and
this is Khotian number.
Khotian
This is
number,
plot
that is-
number.
in the
That is an updated, my lord.
representation that is plot number 3185. in the representation. Lord.
Not part of your writ petition at all.
No, Lord, that is not there.
In the petition, my lord, not
Without,
stated, my
so
lord.
can we do this? Shall I direct the authority to dispose of his representation
My lord.
upon hearing the oil corporation as well as
And
the
upon
state?
going through the
Yes.
critical report, my lord,
Yes.
submitted
Yes.
by the.
Shall I do
that
that
can
without giving another date?
My
Yes.
Let this be disposed of and direct the authority to consider.
my lord. Yes, yes.
That can
And the respondents will be heard when the matter is considered. Yes. The কি বললাম ওটা? In plot number 3186. Learned counsels for the state respondents
3185 as per.
as well as
My lord, may I submit one thing, my lord? This is the report, my lord. Kindly. 86.
6.
this is within the right of use of area of the underground pipeline. The same thing learned counsel is saying.
My lord.
Beyond
Then, my
that
lord.
area, it can be done.
Yes, my lord. Then, my lord.
ওটার সাথে petitioner's submission একটা line add করুন. The petitioners submitted a representation before the concerned authority in this regard, which is yet to be on 22nd May 2023, which is yet to be considered. Stop the petitioners, pray for a direction upon the authority to consider the representation at the earliest. Paragraph. It is submitted on behalf of the state respondents and the 10th respondent that a gas pipeline.
Yes, madam.
Gas pipeline
And
is
mineral water.
running underneath a portion of the said plot. Stop. According to the petroleum and minerals pipelines within bracket acquisition of right of user in land bracket closed.
Section 9, my lord. Section 9.
Section 9.
Yes, my lord. My lord, I'm giving the.
According to section 9 of the petroleum and minerals pipelines, what are they? Within bracket acquisition of right of user in land bracket closed act, 1962.
Subsection 1, clause 1, my lord.
No structure can be constructed on the land under which any pipeline has been laid. Stop. It is not in dispute that pipeline has been laid underneath a portion of the plot in question. Paragraph. In view of the above, this court is inclined to hold that since the representation submitted by the petitioners is pending consideration, the concerned authority being the, who will consider? Should it be the executive engineer? Yes, let the executive engineer consider. Yes, madam. Let the executive engineer consider. Yes.
Earlier, my lord, the order was upon the subdivisional officer, my lord.
Subdivisional officer.
That was passed by the subdivisional officer. Now, they are raising objection, Lord. We have made a representation to the executive
So let
engineer.
it be dealt with by the executive engineer.
Yes.
By the fourth respondent. Be directed to deal with the representation. Directed to consider and dispose of the representation within 1 month.
My lord, 6 weeks, my lord, kindly.
Within 6 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the 10th respondent, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioners. সবগুলো petitioners হবে তো, হ্যাঁ?
If necessary, physical verification may be made, Lord. Physical inquiry may be made.
Physical inquiry is
physical
already
matter
made.
time,
That
yes,
is
my lord.
sufficient. So let the reports be produced. একটা line add করুন এই communication এর আগে. The parties are at liberty to produce necessary documents before the authority at the time of hearing. You can take back this act. এটা ফেরত দিন। আর তো দরকার নেই। Yeah.
Grateful.
চারটে লাইন থাকবে। Disposed of the চারটে লাইন থাকবে। Next.
Item number 20.
My lord, this is my application. My lord, on the, my lord, on.
এটা একটু দেখে
On 8th April. My lord,
Have you
the
served
affidavit of service has been filed, and on that day, your lordship adjourned the matter for the day, my lord. My lord, on 7th March.
Yes, give me a minute, please. I'll just find out.
My lord,
Is the day you are appearing in this one? Private respondents?
Consider the representation. Page 37, my lord.
My lord, page 37 to consider the representation as per order of the coordinate bench, my lord, in a contempt application. That is, if your
As
lordship.
per order of coordinate bench?
Yes, my lord.
If
My
your
lord,
lordship,
SDO was not made a party,
40, my
and
lord.
therefore
Yes.
his lordship directed me, better you withdraw the application and you file a fresh representation. Accordingly, I have filed, my lord,
Page 40,
the learned executive magistrate already started proceeding. First notice, second notice, and third notice. My lord, I have given, I have annexed,
Final order.
but that has not been disposed of up till now.
PWD road,
Yes, my lord, kindly page 48,
10-3 notice was given.
page 48.
40,
My
40,
lord, if
no,
your lordship will come, it will be দাঁড়াও না একটু।
47.
তোমার ফেভারিট হবে। My lord, if your lordship will page 40, my lord. Paragraph
Page?
8. Page 40, my lord.
40.
Page 8, my lord.
This is page
7 and 8, my lord. Paragraph 7 and 8. তোমার
Yes,
ফেভারিট
yes.
order হচ্ছে। ভগবান।
Why SDO?
SBO 10-3?
10-3.
Yes, my lord. 10-3.
My lord, 10-3, now will kindly come to page 47. Under section 10-3.
10-3 notice.
Yes, 10-3, my lord, on several times. Next page, my lord, second notice.
10-3 hearing has not
No,
been.
no, no, it has not been.
The proceeding,
on-
my lord, within 2 months. That is very long pending
My
matter.
lord, kindly dispose of the matter.
Yes,
I'll dispose of directing completion of the proceedings.
Yes,
in 2
yes.
months. Affidavit of service. None appears for the private respondents despite service. Paragraph. pursuant to a representation. Where is your representation?
That is page 37.
37.
Yes, my lord. Page 37.
Yes, pursuant to a representation submitted by the petitioner before the concerned authority, alleging
Page 37.
encroachment of PWD land by the private respondents, proceeding under section 10 of the West Bengal Highways Act 1964 has been initiated and notices issued under section 10(1), 10(2) and 10(3) of the Act. Stop. The petitioner seeks a direction upon the authority to conclude the proceedings within a stipulated time frame. Paragraph: upon consideration of the submission made on behalf of the parties, this court is inclined to hold that since notice under 10(3) of the Act of 1964 has been issued at least thrice upon the private respondents, the concerned authority, being the SDO is respondent number. Five.
Yes, my lord. Respondent number
The
5.
fifth respondent hearing, be directed to take the proceeding to its logical conclusion within 2 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, in accordance with law. Disposed of which
Similar application হয় না তো হয় না কে করেছে petitioner কে petition আপলোড LITD একটা সেকশন 21 24 জানি বাবা স্যার আই এম গ্রেট 24 এ আছে এই স্যার এটা দেখিয়ে দেব আপনি দেখা যাবে না মাইলর মাইলর জানো
Next, item number 21.
Lord, in this matter, my lord, Mr. Shishanu Bandyopadhyay appearing on behalf of state. We are taking a point of maintainability.
Petitioner, you are appearing for state. You are appearing for the state. Petitioner. Petitioner is not appearing, sir. And on the earlier date also the petitioner did not appear. So
Perhaps because my lord, this petition is not maintainable. Because our reading has been the prayer of the expedition below that page 14 below you also candidate. But the prayer is for expedition disposal of an statutory appeal pending before landed DLR. So, as per section 8 of the West Bengal Land.
let this be dismissed for default because the petitioner is not there. I'll deal with the other matters. Let me call, sir. Why are you in a hurry? None appears for the petitioner. No accommodation is sought. Dismissed for default. Puro order recorded. Next. Item number 22.
22 my lord Mr. Sandip Chakraborty. 22 my lord Mr. Sandip Chakraborty is on behalf of the petitioner, my lord. I'm just paying for a day's accommodation, my lord. He's in courtroom number 28, my lord. Kindly.
A day's accommodation takes us to next month.
22.
On prayer of the petitioner, the matter is adjourned. Paragraph: let the matter appear under the same heading on 21st May.
21st.
May. Next. Item number 23.
23 my lord, I am for the petitioner.
Service.
I'm just checking it, my lord. Sir, what have I told? The service, other service is complete, my lord. I cannot see, my lord, whether there's no service report of the, my lord, the government Peter, my lord. Well, I'll come back. I'll serve a copy on the GP's office. I'll come back.
Not today.
Not today, well.
Not today.
Hey, not today.
Next.
Adjournment.
This is for default. I think that's why he has chosen not to come.
24.
Join the dismiss for default. Same order.
0.
Next.
25.
25 also same order. Dismiss for default. The petitioner is not there.
Item number 26.
26, my lord, I am for the petitioner.
Yes.
Here, my lord, service is complete.
Only the state is there, isn't it?
26.
Only state.
Private nature.
Mr. Banerjee is appearing for the state?
State respondent. my lord.
Yes.
My lord, there is, my lord, land of the petitioner, my lord, was utilized. My lord, land of the petitioner utilized without any acquisition proceeding. That is, my lord, my moot complaint, my lord. Kindly seize, my lord. My lord, this is for, my lord, the ILA project regulation. My lord, kindly seize, my lord. I have, my lord, mentioned, my lord, my grievance, my lord, paragraph 4 onwards, my lord. Utilized, my lord, for construction of the bath, my lord. After that, my lord, I made complaint to the executive engineer that utilization without the process of acquisition.
Yes, Mr. Banerjee. It has been utilized. No, that is not in dispute at all. Shall I give a direction for consideration of your representation?
Yes, that will suffice, my lord. At this stage, this will
Because let them
suffice.
consider.
Yes.
They have to in any case consider actually.
Yes.
Which one? There are
Representation, my lord, starts at, my lord, page 15. This is, my lord, to the executive engineer, and the next one is, my lord, to the Secretary, Irrigation and Waterways Department.
So who should consider?
Executive
Is utilized by?
Executive engineer, at this stage, my lord, executive engineer will suffice.
Utilized by the secretary, isn't it?
My lord, for bath, it has been, my lord, construct. My lord, for bath, it has been taken. Therefore, my lord, the executive engineer, the requiring body, my lord, should be the.
That is the executive engineer. So page 15 or 16?
15, my lord.
15. Affidavit of service.
My lord, may I only get a copy of the report, my lord, so that I can.
Submitted.
Okay. My lord, that could have been, my lord, relied upon at the hearing stage.
The court has also not got a copy.
My lord, my lord, my lord.
The grievance of the petitioner is that his land was utilized by the respondents for construction of an embankment without acquiring the same by due process of law, comma, far less paying any compensation to the petitioner. Paying any compensation to the petitioner. The petitioner submitted a representation before the concerned authority in this regard on 2nd August 2021, which is yet to be considered. Stop the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph learned counsel for the respondent submits that the 8th respondent be directed to deal with the representation in accordance with law. Paragraph in view of the above, the writ petition is disposed of, directing the 8th respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month. within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph in the even, it may be a direct purchase issue also.
Well, for that a proposal.
Very good, very good. 6 weeks. I was wondering why you were not saying this. 6 weeks from.
Well, let it be first, my lord, ascertain that at all utilization has been made. After that, my lord, the proposal should come from their side.
That's why I'm not asking for compensation directly, because it has to be a yes. There has to be a proposal. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which action?
Grateful, grateful.
Next.
Item number 27.
My lord, I appear for the petitioner, my lord. Dispose. I have served, my lord. May I file the affidavit of service?
Yeah, very good.
Yes, my lord. 2 to 4, my lord, are the principal respondents, my lord. The Coal India and the Eastern Coalfields. My lord, I'll tell your lordship, my lord, what is this matter about? My lord, there was a scheme, my lord, that was introduced by the Ministry of Coal. That, my lord, if I'm the owner of a land, the land will be taken over or acquired by the coal companies. Upon acquisition of 1 acre of land, my lord, 1 employment will be provided to me, either to me or, my lord, to any person in my family to whom I nominate. My lord, that was the scheme. My lord, I have my lord, there is the deed. My lord, kindly takes, my lord, page 13 onwards.
Ownership.
Yes. Yes, my lord, in fact, lordship kindly sees page 73, my lord. 73 the card deed.
Yes.
Yes. My lord, my predecessor's land was acquired or purchased by, my lord, the respondents, my lord, pursuant to this deed of, my lord, 26 December 1992.
This is a deed of conveyance.
Yes, this is a deed of conveyance. Now, my lord, in terms of the scheme, if I may show the scheme first, it's not annexed, but, my lord, if I may hand over a copy of the scheme, my lord, the typed copy is immediately after that page. Yes, my lord, kindly see, my lord, the next page. I have the typed copy next page immediately. My lord, kindly see serial number A, capital A. My lord, for the land purchased, acquired, used between the period from such and such to 63 for eligibility, minimum 1 acre of land is required for 1 employment, and in case of more than 3 acres, maximum 2 employments from a family. If any person is employed under the land LL means is the land loser scheme. Land loser scheme that should be taken into account for determining the eligibility of employment. The land should belong to the same family. Next, the nominee should be near relation and be dependent to the land loser, upper age limit of 35 years, and should be physically fit for examination. Now, my lord, page 73 is, my lord, the purchase deed that I had shown to your lordship, because in terms of that deed, my lord, I hand over the land to the coal companies, and as a consideration, my lord, they give me the employment. Now, my lord, kindly see the schedule of that deed of purchase, which is at page 92 of the petition. Huh?
Yes.
Yes, my lord, page 92. This is, my lord, kindly see, my lord, 0.15 acres recorded in such and such, then RS plot number, then 0.15 acres. And, my lord, there is another deed. Now, lordship kindly takes, my lord, the next page, my application for employment. 1st of July 2000.
More than 3 acres.
No, minimum 1 acre. 0.30
Minimum 1 acre.
Because, my lord, there are 3 dags. 3 dags. My lord, if lordship kindly takes, my lord, page schedule, my lord, the schedule at page 12 of the writ petition. This, my lord, we have prepared because the copies are not so legible. Yes, this is the schedule
Page 12.
Page 12 of my writ petition.
Yes.
Yes, my lord, kindly see, my lord, RS plot number 196. The acre is 0.04. Then, my lord, lordship will find the subsequent RS plot numbers. The area of land is mentioned on the right hand side column, and total it comes to 1 acre.
Where are these deeds?
My lord, there is only one deed, my lord, which is at page 73.
Yes.
And, my lord,
So how do you say that all these other plots were also taken?
yes, my lord, kindly see my application, which is at page 93.
No, they were not taken away verbally, isn't it? There
No,
must
no,
be
they
some
were not
doc-
taken away verbally.
Cannot be. There must be some
Yes.
documents. So where are those documents?
My lordship, first, my lord, kindly see, my lord, what is the reply? Yes, my lord, kindly see my application. My lord, kindly see, we had nominated Mr. Tushar Kona Mondol, who expired in 2000, and now, my lord, kindly see, we are nominated the third paragraph of the letter
At
of
page-
first, my lord, page 93, 1st of July 2014. My lord, in this, my lord, may I just place paragraph 3 of this letter, the third paragraph. In this connection, please note our nominated person Tushar Kona Mondol, daughter of such and such, expired on 28th of September 2000, and now we are nominating Sri Shoikot Mondol for employment in place of Tushar Kona Mondol. Now, my lord, Shoikat Mondol is the writ petitioner before your lordship who has applied in terms of that scheme, because the lands were taken by the coal companies, and in terms of this land loser scheme, my lord, the document which I had handed over, my lord, I am entitled to employment.
How is it related to the
The related, my lord.
persons? It has to be a close relative.
Yes,
isn't
it has to be a close relative, my lord. Yes. Yes, my lord. I am the heir, one of the heir of the Mondol family, because my father was Ramkrishna Mondol, his brother was Gopal Chandra Mondol and Nepan Chandra Mondol. Malam, from there, I am the son of Ramkrishna Mondol.
Yes, let us hear the authority.
Yes.
My lord, kindly take note of paragraph 8, page 2. They are shown the page 90, where they are stated that they are now completing that application. My lord, on instruction I am submitting 1994 for 50. Say operation Kona Mondol was considered, and it was considered whether he or she has provided employment or Tushar Kona Mondol is a female. This scheme does not provide for employment of a female person. So this ground, it was rejected. It was communicated in the year 1995, which they have not annexed to the regulation. So there is no provision. If I have not gone through this scheme, if we have read, but I believe there is no provision in this scheme. We say that there is a law of denomination. 1993, there is an applicant that is 93 that they have nominated somebody, but it was rejected. Matter 8. There is no provision for denomination.
The rejection is not on record.
So, my lord,
Because the rejection letter was not served.
Obstruction I am submitting has been, my lord, as an opportunity. I can produce that document, the relevant document before the honorable.
You know whether
Yes,
there
my lord,
is
may I?
opportunity for renomination.
There
That
is
has to be
five
done.
I have not gone through this scheme. There is no
No, my lord, kindly see, my lord, page 97 once. This is their document. Because if my learned friend says 96 or 98 being the cutoff date, kindly see, my lord, page 97, which is a subsequent document of 27th of November 2006, issued by them. Kindly see, my lord, the second paragraph of this letter Earlier, the employment file with a reference number such and such was moved in the name of late Tushar Kona Mondol in 1:1 ratio of land loser scheme. At present, the applicants want to nominate for employment to Sri Shoikot Mondol, son of Partho Pratim Mondol, in 1:1 ratio of land loser scheme, considering the old case with a sanction number such and such. Hence, now, very important, the authority is requested for scrutinizing the file, and after proper verification, further action for providing employment may be processed if it is within the company's norms. Company's norms.
The company's norms.
Yes. Now, company's norms, company cannot go beyond this land loser scheme that was initiated by the government, the Ministry of Coal.
That is not in dispute at all.
Yes.
So let them come back with a report.
Very well. In the meantime, I would humbly beseech your lordship would kindly direct them to give me a copy of the document that my learned friend is referring to.
That will be annexed to the report.
Very
You
well.
will be entitled to a copy, right? The petitioner claims employment as a land loser as the legal heir of the owner of the land
May I have your lordship's leave?
who transferred the same in favor of the respondents. The petitioner has based reliance on the guidelines. These guidelines are issued by the authority, by you.
It is the guidelines, as per Prudential Eastern Court. Most probably will be of Prudential. Eastern Court will adopted the guidelines. It does not mention it. I will also try to produce the guidelines also.
So this is only one page.
One page. I will also try to produce
The guidelines for determining eligibility of the candidate to be appointed from land losers in support of his claim. Paragraph learned counsel for the respondents submits that the petitioner had initially nominated that the land loser had petitioner now. The land loser had initially nominated Tushar Kona Mondol, who expired on 28th September 2000. The prayer was turned down by the authority since Tushar Kona Mondol, since there was no provision in the scheme for allotment of for grant of employment in favor of female nominee. Stop. Learned counsel submits that there is no provision for renomination of any other legal heir by the land user. Learned counsel seeks to submit a report in the form of affidavit in this regard, annexing relevant documents. Paragraph, let the matter appear under the same heading on 13th May.
Deeply obliged.
Hello, the report has to be filed. I'm sorry, but I could not.
Yes.
The report in the meantime.
On the adjourned date? Please serve an advance copy so that I can deal with it.
My lord will permit us to, my lord, take an exception to the report if required, my lord.
Yes, on prayer of the petitioner, liberty is granted to use an exception to the to use an exception to the report, comma, if required.
I'm deeply aware.
Next.
Item number 28.
Beg to appear for the petitioner, my lord. My lord, on the earlier order, well, the private respondent is, my lord, not that important, my lord. A direction was passed on the state to submit report, my lord. That report has not been issued. My lord, a copy of the same may be given to us for filing exception, my lord.
Served.
My lord, we have not received.
You to serve the private respondents also. You are appearing for? Please serve copies. You want to use an exception to this?
My lord, I will.
Report in the form of affidavit submitted on behalf of the state respondents is taken on record. Paragraph on prayer of the petitioners, comma, liberty is granted to use an exception to the report. Paragraph, learned counsel for respondent numbers 12 and 13 seeks accommodation. Paragraph, let the matter appear under the same heading on 17th May.
My lord, one
Exchange your exceptions and reports in the
my
meantime.
lord, one more liberty, my lord. Affidavit has been submitted on behalf of the private respondent on the other page. My lord, may we submit a opposition to that? It is a, my lord, affidavit in the nature of a supplementary affidavit, though there is no affidavit earlier submitted by the private respondent.
So, on prayer of the petitioners, liberty is granted to use an exception to the report and affidavit.
I'm grateful, man.
Submitted by the state respondents and the private respondents.
I'm grateful, man.
17th May. Next.
Item number 29.
I am for the petitioner. There's a direction for filing a report.
Received some reports.
Please switch on the microphone. It is switched off.
Yes, my lord. My lord, I have received, my lord, some records, my lord. My lord, I want to file an affidavit, my lord, because I have not checked, my lord, because what happened in this case, my lord, the petitioners, my lord, the case was made out in the writ petitions that the petitioners was not paid crop compensations against the land which was affected for the for the constructions of major thermal plant and the generations of ash. But the fact remains, I have been instructed by the DVC, my lords, as it appears from the records, my lord, that those lands, my lord, were acquired by the Waterways and Irrigations Department, Government of West Bengal. So therefore, my lord, no questions of giving any compensation does arise. Yes, my lord. So at least 10 days, my lords, may be given because of the huge cross-check should be done. Yes, my lord, the state is also.
Is that a very short instruction I have received that since the DVC is paying the compensation previously, payment by us doesn't arrive. That is the only thing I have received.
But now since the DVC says it's acquired land.
No, this is their letter. This is their letter that they have acquired.
Produce the acquisition documents.
A copy of the letter be handed.
May I say this? Yes, Miller. May I say this, Miller? Since 2008-9, I have annexed the documents from page number 41. We are receiving compensations. Miller, now the DVC has been paying, Miller, and Miller, there is a representation when they are not paying, they file two petitions. Miller, there is subject to there is a direction to give a hearing. What happens? The hearing has been conducted by the DVC, Miller, where it has been stated simply that all compensation has been given. So there is an admitted position that compensation has been paid. They are supposed to pay. I'm sorry, I stand correct, my lord. They are supposed to pay. So they are paying. That is admitted position. Now, my lord, our record says we have not received since 2015. Now, let the coming next question, Lord, the owners of my lord, whether the land has been on the name of the petitioners or not, that cannot arise because they are supposed they were paying since 2008 and 9. They have not taken the stance on that time. So, my lord, they cannot come and say that the lands are not be recorded in their name. Hence, they will not pay.
Yes.
That is my submission. my lord.
So, my lord, what we have received, my lords, from the land department, my lord, I'm handing over certain documents, my lord.
Sorry, my lord. There's a survey has been conducted. I need, my lord, I am
Because-
saying that survey report may be submitted with that report. Because that is very important.
Yes, my lord. My lord, this is a letter, my lords, written by, my lord, Deputy General Managers, DVC, my lord, addressed to the Executive Engineer Damodar, Head Works Division. That is the Waters and Irrigation Department. In the above context, this is to kindly intimate that DVC is paying crop damage compensations in some of the mouses affected due to ash deposit for the last few years. From perusal of the records, it has been observed that so many farmers and villagers have claimed crop compensations against the land which were acquired by West Bengal Irrigation Department. For rectifications of the above, you are requested to make available the details of acquired land for constructions of the reservoir of so-and-so. Sri S.K. Kundu, Senior Surveyor, has been authorized for collections of the above informations for your good of it. Then next page, my lord. They have supplied, my lord, all the plots number and box numbers in respect of Sangapur Mauja, my lord. That is jail.
I've seen this.
Yes,
Reports
yes.
are necessary.
Yes, that is reports are necessary and cross-checking. And my learned
Miller
friend
asked
will
them to
also
file
submit
a
a report.
joint survey report also.
But I can take instruction on that.
Yes, yes.
Also, Miller, kindly indicate that joint survey report may be annexed.
And at
in
the
the
same
report.
time, my lords, it would be better, my lord, if I learned friend produce the land records, my lord, at least for draft records, record of rights, whatever might be, that their ownership is to be proved, my lord, and then I can have a cross-check, my lord. No, they have not disclosed in the writ petition.
Because it has been two writ petitions filed, their records has been filed in that petitions, I suppose.
So you have to
Miller, my
file
little
documents and
contention is
submit
what? No, Miller, my say is, Miller, that has been adjudicated already. What my simple question is, Miller, in the page number 111,
Primarily, you need to show your
no, that has gone away. Because, Miller, page number 111, my grievance is page number 111.
you say that since they have been paying compensation all throughout, you don't
Yes.
need to show anything.
Now,
No,
Miller, let them show that they have paid.
they may
Simple.
have paid mistakenly.
Yes, whether
wrongly.
mistakenly, wrongly,
That
rightly.
mistake cannot be allowed to be continued. So
No, Miller.
please come back with your documents showing your right
will
over
come.
the land.
Lord, but let me see, Lord, page number 111, they are saying the compensation will be paid. Let them show documents at least that compensation has been paid. That's it.
111.
111. That is the impugned order.
111 is copy of
Lord, the last
an
page.
order of this court.
No, Lord, I'm sorry, Lord, the last page.
Your lordship was pleased to pass, and this is the pursuant to lordship directions, my lords.
Yes.
Order was passed
Order
on
was
16
passed.
December.
This is under challenge.
Previous round, my lord, they were directed to pay the deficit court fee because there are 119 petitioners. Same order.
But I've come across a division bench judgment which says that if the cause of action is the same, then no separate court fee is
Same,
required.
but if different persons are claiming, it cannot be same.
If the
Different
cause of
moja.
action
It
is
not
the
a
same of all
different
those
moja,
different
different land.
persons.
No, different moja, different land. Cause of action cannot be, in this case at least, it cannot be same.
Then I will come with this, Lord, because they are all in the same area.
Yes, there was a
It's a
direction to pay.
conjoined, my lord, area.
That's why you need to file your documents.
That is why the land documents is required, my lord. It
Your
is our
status
clear
in
case,
respect
my
of the
lord.
land interests.
Yes, my lord. But let them also produce
They
the
will-
documents
they will
that as they have
produce-
claimed that they have
They
paid.
file reports, but you also come back with a supplementary affidavit. Annexing relevant documents.
Yes.
Well, also let them file a state report at least because they were supposed to file a report.
On receipt, I will give our reply.
I think you can take this back. You can.
Yes, yes,
you can
yes.
Annex it to your learned counsel for the.
Kindly come to page 108 once, my lord. In the previous writ petition, very same petition has kindly to the first line, my lord. On their prayer, liberty was granted to deposit the deficit court fee. So they have admitted that it's a distinct cause of action and they paid the court fee on the first occasion. I should point it out to your lordship. First round, they were tried with one court fee. The court pointed out, then they prayed for liberty to pay.
Yes.
No, this is the earlier writ petition. This is not this writ petition.
Earlier writ petition.
Yes, that has been disposed of.
The same default was there.
They come again.
The same petitioners
Yes, my lord. I suppose the same
and you
petitioners.
paid deficit court fees there, so you cannot take a different stand now.
That I have to check, my lord, because I was not
Right?
there.
On record.
So please come back.
Yes, my lord. I will come on that.
And just do the needful in the meantime.
Yes, my lord.
Learned counsels for the respondents seek extension of time to submit the reports in the form of affidavit as sought. Paragraph on prayer of the petitioners, liberty is granted to use a supplementary affidavit annexing relevant documents pertaining to the land in question. Paragraph, let the matter appear under the same heading on
Supplementary affidavit landowner.
20th May.
Yes, my lord. And the petitions which also furnish below that the land records. Yes. No, supplementary affidavit landowner. And yes, and the petitions which also filed below that are land records.
Yes,
Yes, that is.
I'm grateful to your lordship. Yes.
Great.
Next.
Well, 30 and 31 well, same matter my lord against the Gale India Limited. Gale India Limited my lord taken my land. They my lord published proposed rate of the land.
Who is appearing for Gale?
My lord, I am appearing for the respondent.
Proposed rate of the Gale.
Land acquisition officer.
I objected.
Compensation amount has been fixed, my lord. I have with me my instructions. If your lordship so wishes, I can put it on affidavit, my lord.
I objected, my lord, the rate, proposed rate.
My lord, in terms.
Acquired.
Yes, for pipeline, laying pipeline, my lord.
And you have not received compensation.
What is the stand of the Gale, my lord? Kindly direct the my
Under
land
the Act,
exchange.
my lord, I am the pipeline authority, but I am not the competent authority for the acquisition of the right of user or fixation of compensation. Their prayer is that I should determine the compensation. I do not have that power.
I think the state has already
Yes, my
determined.
lord.
Yes,
State
yes,
has
yes,
fixed
yes.
the compensation. If they are aggrieved by the rate, my
My lord,
lord,
point number 5, 6,
under
7.
section 10, they can appeal to
And
the
8.
district
Yes,
judge. Well,
yes.
But I have not received any, my lord, rate.
No, he is not agreed to. He is not agreeable.
Fixed
No,
by
5,
the-
6, 7, 8. May I place, my lord?
Have you served a copy to him?
No, no, my lord. If your lordship so desires, I can put it on affidavit, my lord.
Let him come back on affidavit.
Your lordship, my lord.
Affidavit or sort of report.
And this has to be a report in the form
Report
of
on
an
affidavit.
Report
Yes,
A
that
report.
will help.
Yes, yes. And please serve an advance copy so that learned counsel
Yes,
can
yes,
go
yes,
through
yes.
this.
Certainly, my lord. Certainly.
ঠিক আছে এটাই হবে। হ্যাঁ
It is contended on behalf of the petitioner that though his land was acquired by the authorities for laying pipelines under no compensation has been determined or paid. Paragraph, learned counsel for the state respondents submits that compensation in this regard has been assessed by the special land acquisition officer.
Lordship, my lord.
By the special land acquisition
In terms of
officer,
the statute, my lord.
Purva Bardhaman.
Yes.
In terms of
Lord, your lordship analysis in terms of, my lord, we were derived from the valuation rate per decimal and multiply with the factor 1. My lord, in terms of the, my lord, provisions, as we got it from, my lord, the ADSR office.
Didn't slip the
in terms of all of them.
But section 10 is
We
the
are press six.
statutory provision.
Yes, that is
6, 6 and 7, my lord. Point number 6 and 7. Five, 6 and 7. Compensation based on the ADSR cell data. That is very low. That's, my lord, on the basis of LR department. Suggestive rate, the land compensation value is fixed rupees, my lord.
Have you paid this to the
No, my lord. He is not agreeable. My lord, he, my lord, demanded, my lord, rupees 60,000 per decimal, my lord. 6 lakhs per decimal.
No, have you offered this compensation?
Yes.
No, I have not received anything, my lord.
Lord, I would put it on affidavit, my lord.
Let them file report on affidavit.
Or any notice for payment of compensation?
Yes, my lord, Gram Panchayat meeting was called on, but because it was disrupted, my lord, they didn't attend, my lord.
Meeting again,
But
meeting.
they made a claim, my lord, at the rate of, my lord, 6 lakhs per decimal, but it's arbitrary according to us. my
No,
lord.
that is according to the representation.
Yes. Hearing was scheduled on 18th 8 2022 and 22nd 8 2022. in which no one attended those meetings.
Have you served a notice upon the petitioner saying that please come and take the money?
My lord, hearing was called on, my lord, he didn't come, my lord.
Hearing is prior to determination.
Yes.
After determination, have you served a notice to the
My
petitioner?
lord, on 1st October 2020,
Where is that notice?
my lord, the third page.
What does the notice say? This is a hearing notice, not a
Yes.
payment notice. I'm asking about a payment notice.
Fine. Done.
The petitioner did not appear for the hearing. You have decided the compensation. Have you sent a letter to the petitioner saying that please come and collect the money? Or give your bank account number or whatever?
No, my lord, we didn't.
That has to be done.
Yes.
Please issue a payment notice in the meantime.
Yes.
Has been determined, right? For the one, but no notice has been issued upon the petitioner for payment of the said amount. Learned counsel seeks to submit a report in the form of affidavit in this regard, annexing relevant documents. Paragraph, let the matter appear under the same heading on 16th May.
Yes.
Deeply obliged. My lord, may I get back my instruction?
Yes, 8 of April.
পরেরটা কি আছে রে?
You can annex this to the report.
Yes, yes, yes.
Next.
Extremely good.
Next also মানে same মানে two brother are there, my lord.
Next, same matter.
Same matter.
My lord, I am not appearing in the next matter.
My lord, I am appearing for GAIL India Limited.
But state মানে state is different. কেউ নেই না? তুই দাঁড়িয়ে
There is your affidavit of service.
My lord, today I missed the brief. That was a late time, my lord. Adjourn
I have to adjourn the matter.
Monday.
I'll just make it not today then, because the same order will be passed.
Grateful.
Not today. Next. Lordship, item 32. 31 টা কি হলো? Yes, 32.
My lord, state came. Earlier matter, 31.
You are appealing for the state? State. So let the same order be passed. A report should be filed. Yes, Lordship. Compensation has been assessed, but you have not sent a payment notice to the petitioner. So please send a payment notice to the petitioner in the meantime. Okay. Because if he is aggrieved, he can take recourse to law. Okay. Right? And please come back with a report in the form of an affidavit. Okay. Omla, same order.
I deeply object. Shantanu instruction.
Yes, 32.
Your Lordship, I beg to appear for the petitioner. Your Lordship, last occasion, Your Lordship was directed to serve the state. My lord, my senior friend is appearing, but unfortunately, the petition has expired. I have to file a substitution application.
My lord, he may, but at this stage, I cannot. He hasn't annexed any document of, my lord, land records claiming compensation. Determination has been made. He has to prove and take. Now the heirs have to go and take.
Let the heirs come back. Let the matter go out of list for the time being. Come back with an application for substitution.
Grateful.
Learned counsel for the petitioner submits that the petitioner has expired during pendency of the recusal. Stop. Learned counsel seeks to take necessary steps in this regard. Paragraph, let the matter go out of list.
Respondent 9.
Company.
Next.
Deeply obliged, my lord. Because I was at fault on the next day. I was sitting since 10:30.
Yes, the respondents were not represented.
I was sick.
Last occasion, they have filed a report, but they did not serve the report.
You are the petitioner.
Lordship, I am for
You have not received
I am
copy
for
of
the
the
private.
report.
Lordship, I am for the state.
Give the copy.
We are for the state. Lordship. I am for the
You have not
private.
served copy of the report.
Lordship, I have served a copy of petitioner. Not only Lordship, I am submitting the service. I serve for it. Taking.
The petitioner
Who has
says she
received?
has not received.
My lord,
Who has
have the
received?
receipt.
Oh, Lordship.
Lordship has received.
Lordship, my junior will take the Lordship. But external,
Just,
Lordship, then I'm
just
praying for
now
only
they
1 week
have
time.
handed over the report, my lord.
Yes.
Just now they have handed over the
Lordship,
report.
the
Please
fact
give
of the case, Lordship,
Why don't you annex the documents to the report?
Lordship,
This is the report submitted.
Lordship, this is, I am
They didn't
take
send
back
that
the,
report, Lordship.
I am take back the last occasion I have submitted the report, the entire divested part holder. Now I am submitting the only petitioner. Lordship search the petitioner regarding the subject matter of the petitioner. I am submitting the petitioner report. Lordship, kindly see the report.
So you're submitting this.
Lordship,
today?
Lordship, you take back the last occasion report.
You cannot take back, sir. It is on record.
Lordship,
How can
Lordship,
you take it back?
pursuant to Lordship order, the alternative land has been given.
They have served today, so let them go through the report and come back.
Lordship, he has received.
That goes up that copy, Lordship. That report, Lordship.
But today he's serving this, he's filing this report.
Lordship, he has received. Lordship, pursuant to Lordship order, the alternative land has been given to the petitioner.
You are appearing for the private respondents.
Yes, my lord.
Let's serve copy today, let them come back.
Only 1 week time, Lordship.
Lordship,
Takes us to
it's
next
a
one.
teeny matter, Lordship. It's a small matter. Lordship,
I understand.
Maybe, but Lordship.
Lordship, the land has been given. Alternate land has been given, but the petitioner declined to accept the same because they are told that they have submitted a deposition that they have made a house on the same on the divested land. So they are not accept the land alternative land. They are declined. So what can I do?
Let them come
Let
back.
me
I will-
instruct
let us
for
see.
my client.
Let us see. A further report. Further report submitted on behalf of the respondents is taken on record. State respondents is taken on record. On prayer of the petitioners and the private respondents, comma, the matter is adjourned. Paragraph, let the matter appear under the same heading on
Receive correct.
9th May.
Lordship.
9th May. Next.
Page the matter number.
My lord, I am appearing for the petitioner. I am praying for not today. Because my lord, the RO, we have applied for the ROR request. It needs time to get now at least a month.
Not today to হয়ে যাবে তো আবার
On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 20th May. Next.
In this matter, Mr. Shishana Bandyopadhyay and Mr. Tapati Samant are appearing on the behalf.
It's a report in the form of affidavit.
Lord, may I file the report?
Have you served?
Yesterday. On 4th, my lord, we have served it.
Yes, we received it.
Exception section of
Exception, no.
Well, the point is,
exception.
may I give a background, my lord? We have obtained.
So, my lord, no exception is being filed by my lord.
Lordship, after my submission, Lordship will.
Do you want to file an exception or not?
Yes. Otherwise, making submissions makes no sense.
Lordship, then my lord, let me use an exception.
ছোট করে একটা 5 করো না
And you have to decide whether it is
Or
necessary.
did I use an exception?
Report in the form of affidavit. Report in the form of affidavit submitted on behalf of the respondents. Paragraph on prayer of the petitioners, comma, liberty is granted to use an exception to the report. Paragraph, let the matter appear under the same heading on 21st May. Please serve an advance copy.
21st. But isn't that the last?
21st.
No.
That's not the last.
21st April.
May. I'm great.
There's a circuit bench from 22nd. Next.
I am for the petitioner, my lord, appearing on behalf of Arindam Das. My lord, he could not come court due to some personal difficulty, paying for not today, my lord.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear
Grateful,
under the
madam.
same heading on 20th May.
20, grateful.
The 37, my lord. I am also, my lord, seeking 1 day accommodation. My lord. I have left brief at my residential chamber, my lord.
1 day takes us to 20th May.
20th May. My lord, otherwise, my lord, without brief, I should not, my lord, advance argument. My lord, what happened?
I think you cannot.
My lord, a portion of land has been allotted to me by the KMDA authority. My lord, subsequently, we have received one communication from the KMDA authority, and that particular communication said they have allotted this particular land to some other person. This Honorable Court was kind enough to direct KMDA authority to file their report. In the report, they have very categorically submitted, nothing happened. That at a considerable period of time.
Where is the report? Please submit it. Let us do some work.
Yes, yes, yes.
But this petition has been made mere apprehension.
Certainly not, man.
And without any basis.
I'll show annexure.
This sort of petition should be dismissed with cost.
I'll show my lord the annexure.
Please come. Report in the form of affidavit submitted on behalf of the KMDA is taken on record. Paragraph, on prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 16th May.
16th May, deeply. We have prepared our exception also, my lord, so but their report.
On prayer of the petitioner, liberty is granted to use an exception to the report. Let the matter appear. No, sir,
He need not place his petition. He will place my report.
Yes, well, admitted, my lord.
Next.
Junior,
Number 38, my lordship, I am for the petitioner. Lordship, on that on
My lord, I am for the respondent. Number, my lord, 4.
Lordship, on
Who's appearing for the state? Mr. Roy was appearing, Mr. Siddiqui.
Mr. Siddiqui is appearing.
And for respondent number 11 also someone was appearing.
There are 6 respondents, my lord.
You are for?
4th.
Executive Engineer PWD?
No, my lord. The 38.
38.
Answer only. My lord, I beg to be correct.
You're not in this.
No.
For 11, Mr. Maiti was appearing.
Yes, lordship.
No one.
My lord,
as of we don't know.
I do not find the respondents at all.
My lord, I am for 11. I'm for 11, my lord. But I beg to be corrected.
My lordship, on the dated 15/6/2022, Honorable Justice Mr. Mohammad
A
Nizamuddin.
report was called, yes, from the respondents. But today the respondents are not there.
No report yet had been received.
Mr. Siddiqui is appearing.
And
Other
no physical verification has been done yet.
So let me fix another date.
Okay.
Will you please inform the state respondents only about the next date?
Absolutely, my lordship.
None appears for the state respondents. No accommodation is sought. Paragraph, let the matter appear under the same heading on 10th May.
10th.
Much obliged.
My lord, item number 728, 730 to 751, 753 and 54, my lord. In all these matters, Mr. Arindam Das is appearing. My lord, he has mentioned before your lordship yesterday, my lord. I'm on that ground, due to his personal difficulty, could not come to court. I'm just seeking for a day's accommodation, my lord. Kindly keep it on Friday, my lord. There's some urgency in the matter, but due to some personal difficulty, my lord, we are bothering your lordship like this, my lord. Just for a day's accommodation, my lord.
729 728 730 থেকে
Please tell me the numbers.
my lord 728
Shall I make them not today only?
just that's not today my
My
lord just not today my lord
এটা একটু note
না,
রাখো।
স্যার 751 পর্যন্ত।
24 টা matter not today.
730 থেকে 751
Yes, second
Ballot up to 751. Then 730 to 751.
দিদি এই যে নাম্বার
728 to
my lord
Sir,
728 only 730 to 751 and 753 754
please.
I have mentioned the number my lord
728 only and then
730 to 751 my lord
730 to
yes 751 my lord till 751 and thereafter my lord 753 and 754 only
till 751.
yes
All of these.
yes and then my lord 753 to 754 my lord might see the all of them are filed by Diptangshu Kaur my lord
Deeptangshu Kaur, yes.
yes my lord all this matters my lord in all this matter Mr. Dash is appearing
728 is Apurva Group.
and, yes my lord yes it's included in it
753, 754.
my lord
These matters are being made not today.
not just not today my lord grateful lord extremely grateful lordship not today Shukrobar
Because he had appeared yesterday, he said. yes,
my lord grateful lordship
Yes, 729.
Gosh, I beg to appear on behalf of the Kolkola Local Corporation of 720.
I beg to have the petitioner. Yeah, my lord,
Before my learned friend starts a similar matter.
I am submitting on that point.
Okay.
But here, my lord, two writ petitions have been filed by the petitioners. One, my lord, against the KMDA authority, and other is, my lord, against the corporation authorities for issuance of section notice 401. Well, that matter came up for hearing before Justice, my lord, Rajashekar Mantha. Right.
This court cannot deal with.
No, his lordship has been pleased to direct that both the matters be heard together.
This
Right.
cannot be
Before which bench? It has to be assigned.
unless one is assigned.
Yes.
It cannot be heard.
Did you
I
do
know.
order?
Still steps for assignment.
Yes.
But unless, my lord, your lordship releases the matter, my lord. Because my lord has got that
This order
determination,
was
my lord,
passed.
with regard to the land matter.
This order was passed in group 5 matters.
But the cause of action, my lord, is altogether different.
Petitioner is clever enough. In
But
one matter,
question of
challenging the acquisition, he has filed in group 1.
Both
And in
matters-
another matter,
Both challenges could have made in one petition only. They have made a separate
No,
petition.
no, my lord.
In
cause
one,
of
they have
action-
challenged the letters issued by the
No, my lord,
KMD.
cause of
On
action is
another
different.
matters, they have challenged the notice issued by KMC on the basis of these letters.
No, my lord, the cause of action is different. One, my lord, against the corporation for issuance of notice under section 401. Because of the fact that there is sanction
Let
plan.
me release this matter. Because the other bench wants to hear both these matters.
My lord, my lord. Question of cleverness does not arise.
you know that better.
Take it as a compliment, sir.
He always my lord, makes compliments.
It appears that by an order passed on 29th January 2024 in WPA 972 of 2024, a coordinate bench of this court has observed that has directed listing of the present writ petition along with the matter pending before the learned court. Paragraph in view of the above, the writ petition be released.
In group 5 matter, KMDA was not made party. In this
Well,
order, the honorable
Not
court
required, my lord, because it is against the corporation. That's why KMD was not made
and
party.
this of KMDA.
Write it out before the other bench.
Grateful.
Next matter.
We are unlucky.
Now,
Yes.
this is for expansion of a road without execution any.
Who is appearing?
This is affidavit of service I have served. PWD roads cannot do it without acquisition of land. The state has received.
The state is there and national highways.
Southwestern Engineer PWD roads. Now they are constructing a expansion of roads without.
Serve the state.
Demand justice I have also made. I have also give objection. But I have also
Mr. De, may I request you to appear in this matter? State has been served. There is no one. Yes, what is the matter? Please serve a copy.
कॉपी तो नहीं हो रहा है ना हो जाए दी हम कॉपी road is expulsion by the executive engineer PWD roads without acquisition of land. Plot number 713. This is my own land. There is my shop room. I made objection to the engineer Miller, did not pay any heed. But a demand justice also filed by me on behalf of my client Miller. They did not take any steps till date.
My lord, you can file an application before the authority that will be considered. That is demand justice.
He has already filed an application, I think.
Yes, my lord, I have already filed.
Before the demand of justice, there is an application.
Then, my
also.
lord, that will be considered by the authority.
There is your representation?
My lord, Mr.
Yes.
Oh, you are appealing.
P3, my lord, P3, page 25. Instruction. No.
Page 25.
Last time.
That is a demand of justice.
Demand justice.
Where is your representation? There is no representation on record. So let him file a comprehensive representation. He says that you are utilizing his land without acquiring it.
Let him file a.
Will you file a representation before the authority? Let it be considered within a stipulated time frame. Yes?
My lord.
Affidavit of service. Until disposal of the representation, no further construction on the petitioner's land. The petitioner claims to be the recorded owner of the plot in question, affidavit of service, and submits that the respondents have been trying to construct a road over the petitioner's plot without acquiring the same by due process of law, and have already constructed a drain therein. The petitioner seeks to submit a comprehensive representation before the concerned authority in this regard and prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits that who should consider?
This is the Southwestern Engineer PWD Road, Baripur, Sonarpur, Division.
Let two consider.
The second respondent be directed to consider the representation in accordance with law. Paragraph. In view of the above, the petition is disposed of with liberty to the petitioner to submit a comprehensive representation ventilating his grievance before the second respondent within 7 days. Within 7 days from date, stop. The second respondent is directed to consider and dispose of the representation within 2 months.
We'll make it 6 weeks because your lordship is not passing some in.
Within 6 weeks from the date of
Let there be some pressure.
communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof. Paragraph. Pending disposal of the representation, no further construction shall be made by the respondents in any portion of the by encroaching upon any portion of the petitioner's land. Disposed of which chapter? Next. Receipt thereof. Communication.
I appear for the KMDA in this matter. There was a earlier occasion, there was a direction.
My lord, I am for the petition. The lordship was pleased to direct my lord the state respondents to my lord demarcation and to submit a report to that effect, my lord.
Let a copy be
My lord, may I
circulated.
have a copy of that, my lord?
Demarcation made in presence of the others,
Yes, yes.
I am yet to receive, but you will give it.
in presence of the petitioner.
In presence of the
Yes.
petition.
Entire plot has been acquired, my lord.
It appears
By 3
Entire
lakh,
plot has been
entire plot.
entire plot has been.
Well, let me go through the report because my lord, I've got no
It
instruction.
was done in his presence.
No, not in my presence.
You have received copy
You mean the petitioner.
today?
My lord,
You received the copy today. You want
today, just now.
to use an exception? No,
Well, yeah, I cannot,
you cannot see. Yes. A report in the form of affidavit.
but my lord kindly grant liberty to file the exception if necessary.
On behalf of the state respondents is taken on record. Paragraph on prayer of the petitioners, common liberty is granted to give an exception to the report. Paragraph, let the matter appear under the same heading on 21st May.
21st May, 21st. Deeply.
Please serve a copy in the.
My lord, I always try to.
Demarcation was done in presence of the petitioner. Yes, attended.
Let him come back.
They are lay persons, they don't know the.
Led by Mr. Bandyopadhyay.
He will make out a case. The petitioner has no case.
Led by Mr. Bandyopadhyay. I'm led by Mr. Bandyopadhyay, not the other.
Petitioner,
756, ma'am. I am for the petitioner, my lord.
756 petitioner.
Petitioner, my lord. Here is my affidavit of service, my lord. Two affidavits, are one for service of copy and another for mention after mentioning. Two affidavits of service, my lord.
Are there private respondents also?
My lord,
Yes,
I
my
am
lord.
for private respondent number 325.
Very well.
There are three private respondents.
Yes, what is the matter about?
Matter is, my lord, this is a Salt property, my lord. According to Government Grants Act, there should be no transfer. There is an embargo in transferring the property, but suit property has been transferred. I have given representation before the UD department to take steps regarding cancellation of transfer deed of private respondent number 325. UD department did not consider my representation. Representation at my lord is at page 60. I have
You're asking for a direction to consider this?
consider my representation, my lord, so that their proper steps can be taken by UD department to cancellation in respect of the said deed.
It has been transferred by the petitioner, by the.
No, respondent. Respondent number 5 have transferred to respondent number 3 and 4.
Oh.
I have annexed the deed, my lord.
Considered? You will be given an opportunity of hearing.
My lord, I am praying for an direction to file affidavit in opposition.
I know you will ask for such direction and it will be rejected by this court. Let it be disposed of. You will be given an opportunity of hearing before the authority. Mr. HON'BLE is appearing in this matter. State,
I have served, my lord.
who is appearing?
নাম লিখেছেন?
The state is served. Why don't you appear? Consideration of representation. Affidavit of service, none appears for the state respondents despite service. Mr. HON'BLE, who is present in court, regularized quorum. Please serve a copy of the writ petition to Mr. HON'BLE.
My lord, I
Copy
serve.
service a direction.
During course of the day, I shall serve.
Yes. Paragraph, it is submitted on behalf of the petitioner.
ঠিক আছে,
that
কথা ফোন নাম্বার
the-
দিয়ে কথা বলে না।
How are you affected?
My lord,
By the
I
transfer?
have pleaded in my petition paragraph number 5, my lord. Paragraph number 5. This respondent number 5 has entered agreement with the petitioner to transfer the leasehold right after prior permission, obtaining permission from the concerned authority. He has entered into agreement with the petitioner to transfer his leasehold right. But after that, he has transferred his property sold, my lord, rather.
and submits that learned that though the fifth respondent agreed to entered into an agreement with the petitioner for transfer of leasehold right in respect of the property in question in his favor upon obtaining prior permission of the government, the said respondent has sold out the property.
I have annexed
in
the deed,
favor
my
of
lord.
respondent numbers 3 and 4 in contravention of
Government Grants Act, my lord. Provisions of Government Grants Act.
the provisions of the Government Grants Act. Government Grants Act, you have stated.
Government Grants Act. I have pleaded in my petition, my lord. There is a lease deed of 20 clause, my lord, and 17 clause and 20 clause. And government
Contravention of the Government Grants Act.
Government Grants Act. my lord.
The petitioner
Do not-
submitted a representation before the concerned authority seeking cancellation of the registered deed of conveyance executed by the fifth respondent in favor of the third and fourth respondents. Submitted a representation section of representation before the concerned authority in this regard in this regard on 21st November 2023 for seeking cancellation, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the state respondents submits that the second respondent be directed to
land manager, my lord.
consider the representation in accordance with law. Paragraph. In view of the above, the writ petition is disposed of, directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 1 month.
Some more time. The election is there.
Yes. Within 6 weeks from the date of communication of this order,
Much of.
upon affording reasonable opportunity of hearing to all concerned, including the petitioner and the private respondents, in accordance with law. Paragraph. The decision taken by the authority shall be communicated to the petitioner within a week thereof, disposed of which at length.
Much obliged. Keep doing this.
Next.
Not application, my lord. Well, this is the affidavit service, my lord. My lord, petitioner has a land, my lord. In front of the petitioner land, my lord, over the.
Have you served all of
Yes, my lord.
Give me
Yes,
a minute.
Yes, my lord, I've served. Including the private respondent, my lord.
Mr. De, may I request you to appear?
Well, kindly come to page 27, my lord. In front of.
PWD land.
Yes, my lord.
PWD
Yes.
land.
PWD land, my lord, they are unauthorized constructed, my lord. I requested them not to do that, my lord. And that creates my problem in egress and egress. And my lord, I made a representation, page 27, to the assistant engineer, my lord, and also the police authority.
Please serve a copy to Mr. De. Let it be considered by the assistant engineer. Affidavit of service. None appears for the respondents despite service. Mr. Their appointment regularized. It is submitted on behalf of the petitioner. The petitioner claims to be the recorded owner of the plot in question and complains that the private respondents have raised unauthorized construction by encroaching upon PWD road adjoining his property, thereby obstructing his egress and ingress.
Well, in front of my property, my lord.
Adjoining.
Yes, my lord.
Yes, I've stated that.
Yeah, I'm sorry. I'm sorry.
The petitioner submitted a representation in this regard before the concerned authority on 19th December 2023, which is yet to be considered. Stop. The petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the sixth respondent be directed
Yes.
to consider the representation in accordance with law. Paragraph, in view of the above, the writ petition is disposed of, directing the sixth respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 3 months from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of.
My lord, accordingly, my lord, in consequence, step will be taken, my lord, if they.
That is in the act itself. 1964 Act says so. Next, interpretation of the act is not required. দাঁড়ায় নি তো none appears for the respondents বললাম ওই যে কেউই দাঁড়ায় স্টেট কে রেল করলাম প্রাইভেট respondents.
In that matter, I am for the private respondent number 9 to 12.
Well, like, I'm for the petitioner, Mr. Shoibal Acharya, appearing for the petitioner. He is in Shraddh ceremony of his family. I'm praying for my lord not today.
Why make your submission? It's a very simple matter.
This is the earlier occasion petitioner came before your lordship and your lordship passed the order directed to consider his representation. That is main grievance of the writ petitioner is that fee ingress and egress obstructed. Kindly see the photograph.
Let
Lorry
she's not
is
ready.
passing.
Let her come back. On prayer of the petitioner, that these are simple matters, madam. Why did you come prepared? These are very simple matters.
Fee ingress and egress. That is the main grievance of the writ petition. Earlier occasion your lordship directed
Take up
to
small matters,
and
simple
also
matters, and start mentioning.
and also district magistrate passed the order.
On prayer of the petitioner, the matter is adjourned. Paragraph, let the matter appear under the same heading on 9th May.
Grateful, my lord.
Next. Petitioner 759. Anyone for the petitioner? No one.
There are so many cases, my lord.
Yes.
Another statement. As because there are 759 that is organ of the Santa. That is 765, my lord. I pay 5, my lord. And that's because there are up to 765.
This will be 9.
None appears for the petitioner. On the earlier date also no one came.
My lord, as because the case is very bad, my lord. For that.
This is very bad. Shall I make?
My lord, is Calcutta wetland case, my lord, and if your lordship will see, my lord, that is the last.
So they let it be dismissed for default.
My lord.
Yes, because on the earlier
Yes, my
occasion
lord, yes,
also,
my lord.
on the earlier occasion petition did not turn
Yes,
up.
my lord.
None appears for the petitioner. No accommodation is sought. Dismissed for default. আমি ডাকছি সবগুলো একটা করে। Yes, next time. ডাকি একটা একটা করে। Let me call one by one.
Yes.
Anyone for the petitioner? দিতে হবে না কিছু। কেউ একই রকম। 760, anyone for the petitioner? None appears for the petitioner. No accommodation is sought. Dismissed for default.
And for this case.
Same order. Same order.
I'm for the state.
Same order. Dismiss for default. Dismiss for default.
I put the statement.
Dismiss for default. None appears for the petition.
I am for the petitioner, my lord. My learned friend is on the line, my lord.
Who is online?
I am submitting the affidavit of service, my lord.
Yes.
Lordship, in item number 766, my lord, this matter relates to removal of unauthorized encroachment from government
Yes, have
land.
you
Your Lordship.
served the private respondents?
My lord, I have served.
Respondents are complete, your lordships. Upon all the respondents have been complete, your lordship. Lordship, the petitioner is before your lordship only with the prayer that his representation dated 15th January 2024, your lordship would find it at page 21, your lordship. Annexure P2, page 21. That representation may kindly be directed to be considered, your lordship.
Very well.
Section 10 application, it will be considered. Yes.
Affidavit of service, none appears for the private respondents despite service. Paragraph, the petitioner claims to be the recorded owner of the plot in question and submits that the private respondents have raised unauthorized construction by encroaching upon PWD land, adjoining her, thereby obstructing her egress and ingress. The petitioner submitted a representation before the concerned authority on 15th January 2024, which is yet to be considered. Stop, the petitioner prays for a direction upon the authority to consider the representation at the earliest. Paragraph, learned counsel for the state respondents submits that the third respondent,
Yes,
Yes, third respondent.
be directed to consider the representation in accordance with law. Paragraph, in view of the above, comma, the petition is disposed of, directing the third respondent to consider and dispose of the representation submitted by the petitioners dated such and such within 3 months
Yes.
from the date of communication of this order, upon affording reasonable opportunity of hearing to all the interested persons, including the petitioner and the private respondents, comma, in accordance with law. Disposed of. Next.
But
Yes.
first of all, I pray for some liberty for correction of cause title. Some typographical mistake is there.
Correction of?
Cause title.
Have you served?
Yes.
Where is your affidavit of service? Only the state.
Yes.
Mr. De, may I request? Please serve a
But
copy.
he is appearing, madam. He has been engaged. Yes, I have served notice also.
Mr. De.
I have not coming with the brief.
The matter is the land was requisition for the particular purpose, but thereafter no acquisition process was initiated, but land has been utilized.
48 Act.
No. Yes, 48 Act requisition.
Yes, yes.
At the stage of requisition,
Land was
road has
taken.
been constructed without proceeding any acquisition proceeding, madam. This issue has already been settled by the division which I have annexed that order, my lord. And similar matter, my learned friend appear in the HON'BLE district, give proposal for direct purchase. And your lordship also dispose of that matter, my lord. I have
Yes.
annexed the division bench order, my lord. Where the acquisition process was noticed, that has to be initiated. 767. Starts from page 37.
I think Mr. De will need some time. Shall I?
Yes, my lord, I have.
He is not ready today. Let him come back.
And
Because this order was passed on consent of parties.
yes,
Even the state admitted that the matter has been settled by the division bench.
no,
It was submitted
states
by
appeal.
both
The states appeal.
Yes, it was submitted by both the parties that the issue has been decided by the division bench.
Yes, this is admitted. I have annexed that.
So let Mr. De come back.
In the HON'BLE district, my lord, this type of matter one mixture, they appear their proposal for direct purchase. May I give?
Please
a
give a copy to Mr.
Yes,
De.
yes.
Please take
Please,
instructions.
send it.
To direct purchase.
Yes, so also with them.
Mr. De, please take instructions and come back. Affidavit of service. on prayer of the state,
Liberty, my lord, correction. Correction.
on prayer of the petitioner, liberty is granted to correct the cause title of the writ petition. Paragraph, learned counsel for the state respondents seeks to take instructions in this matter. Paragraph, let the matter appear under the same heading on 14th May. Next.
Lord, my writ petition, Lord, essentially praying for, my Lord, enforcement of a covenant in a mining lease. Lord, the scheme of
Force majeure clause.
no, my lord. The scheme of the act is, my lord, that once we, my lord, receive my lord, a lease. First, my lord, we must be, my lord, under the new act, my lord, we must get mining rights. Then, my lord, we have to approach the state. State, my lord, will execute a lease deed in my behalf. Now, after that, often it is the situation that where, my lord, we will be mining, that is, my lord, under private land. So therefore, the state, my lord, under the statute has to acquire and, my lord, give me the land, or acquire the subsoil rights and give me the land, etc. Now, in this case, my lord, what has happened is we got an allotment, and then subsequently, my lord, mining lease was executed in my favor by the state. State, my lord, in terms of, my lord, if your lordship is pleased to see, my lord, the lease deed at page 200. Clause 2. If in accordance with the provisions of clause 4 or part 7 of this schedule, lessee shall offer to pay to an occupier of the surface of any part of the said land compensation for any damage or injury which may arise from the proposed operation of the lessee, and the said occupier shall refuse his consent to the exercise of the right and pass reserve to the state government and demise to the lessee by these present, the lessee shall report the matter to the state government and shall deposit with it the amount offered as compensation. And if the center or state government are satisfied that the amount of compensation offered is fair and reasonable, or if it is not so satisfied, lessee shall have deposited it with such further amount as the state government shall order the occupier to allow the lessee to enter the land and carry out operations. In assessing the amount, they shall be guided by the land acquisition. So, my lord, the sum and substance is I have to go and, my lord, offer. If he refuses, I have to go and inform the district magistrate that this is what I had offered. District magistrate will, my lord, apply Land Acquisition Act provisions and make me deposit with him. And then, my lord, acquire and give me, my lord, rights. This is the procedure. Now, my lord, what has happened is this lease, my lord, the deed starts from page 171. I'm sorry, my lord, I've given a wrong page number.
It's 169, I think.
Yes, my lord, 169.
Right.
Yes, these letters are part of it. 169. This lease deed, my lord, is of May 2023. Thereafter, my lord, I'll be very candid. My trade rivals, my lord, have ensured that in the locality, people, my lord, don't cooperate with me. That doesn't matter, because whoever is, my lord, objecting, going and filing a suit against me, getting an injunction order, ultimately when the acquisition happens, I'll be able to get everything vacated. Till the time the acquisition of the state doesn't happen and the state doesn't give me the rights, I won't, my lord, to be able to do anything in this before the civil court. So, my lord, kindly take page 226, 225. I have written to the BLRO, Lord, a comprehensive letter that under the provisions of the Coal Mines Special Provisions Act and the rules, nominated authority conduct an auction by which, my lord, we were declared as successful at Raningganj coalfield. Vesting order issued by the authority. Then, my lord, mining lease executed in our favor. Now, this is the provision in terms of the lease deed, whatever, my lord, the acquisition provision, and my lord, the compensation provision. Now, please, my lord, see paragraph 4. SS Natural Resources surreptitiously purchased, he's my rival, surreptitiously purchased 56 decimals of land from the erstwhile owners in 22. My lord, when they got wind of my coal block, they went and, my lord, purchased some land for the other private owner, and they've obtained, filed a suit, etc. Now, so therefore, you please, they are objecting, so you please do the needful. Next, my lord, page 227. The BLRO, my lord, responds saying that with due respect, it is to inform him that the undersigned is not the competent authority to resolve issue. The applicant may consult with the Department of Industry, Commerce and Enterprises. Now, my lord, I write to the Principal Secretary, page 228, Commerce and Enterprise, at page 228. Lord, there is nothing. Now, my lord, under your lordship knows, your lordship takes up, my lord, all these mine deallocation matters. In fact, I was also, my lord, briefed in one of them, so I know that if you don't do it within milestones, central government will, my lord, deallocate the mine and, my lord, take the bank guarantee, which your lordships, my lord, we come and challenge before your lordship when that happens. Now, here, my lord, the clock has started ticking. Now, my trade rival has surreptitiously purchased a little bit of land and is, my lord, stopping the entire, my lord, mining operations. When I go to the state government, I'm saying the state government, you have to follow the act and the lease, and, my lord, the lease deed. If you acquire and you give me rights, then I'll go and get orders vacated. My lord, other than that, I don't have any cause of action. Till that time, a private owner is entitled to stop me. Till that procedure is carried out. State is doing nothing. My lord, how can industry, my lord, survive in this state?
Let's hear the state.
But this one, application on at page 220 is pending. That is appears for requisition. Either your lordship direct the authority to dispose of this representation, or I have to take order.
Vesting order দিয়ে দিয়েছে।
Application at 228.
Yes, my lord. 228. What else it
Will
is?
that serve your purpose if the authority is directed to consider this application?
And, my lord, whichever department of the state, either it's, my lord, BLRO or, my lord, the principal secretary, whoever has to dispose it of should do it.
Let the principal secretary do.
Yes, yes.
Let him do it. And within a time frame.
Within 1 month.
1 month.
Yes,
Let him do it within 1 month.
My lord, 2 weeks, my lord. My lord, these are all time bound. My lord, my entire coal mine.
2 weeks will be too much for the principal secretary.
My lord, my coal mine is, my lord, kindly see, I have got a coal block. Kindly see the
I understand.
cost.
Let it be 4 weeks.
4 weeks. But positively, my lord, if your lordship, my lord, forces him
This
to.
is always positive, sir. They're never negative.
My lord,
Has to be
this
complied
is,
with.
my lord, something the state should do. What is this?
Mr.
Yes, yes.
Gordon, please give the necessary instructions to your client.
Yes, sir.
Affidavit of service. No. It was service. Affidavit of service. Heard learned counsels for the parties. Paragraph. Being the highest bidder, in any auction floated by the authority under the Coal Mines within bracket Special Provisions Act, 2015, bracket closed, read with Coal Mines within bracket Special Provisions Rules, 2014, bracket closed. At 14, so 2015, 2014. Rules are at 15. That's it. Page 225 is the page. Mining lease was executed in favor of the petitioner on 11th May 2023. In respect of a total area of 856.68 hectares.
Hectare, no, I'll just check. No, it's there in the lease deed also.
Paragraph 2 of your
Yes, yes, Lord. No, it's there in the vesting order, Lord. I'll just. Lord, if your lordship comes to page 159, this is the vesting order. And the total area is not mentioned. Latitude, longitude is mentioned at page.
It's mentioned in your representation at page
Yes, my lord.
28.
It will also be mentioned in the lease deed, my lord. I'll tell your
Yes,
lordship from the lease deed.
Has to, yes. 169.
Yes, my lord. Lord, it's described in the schedule. কোথায় পাচ্ছ তুমি? Lord, it's
The total
I'll just add
is
up.
not given there.
Total is not
But
given.
let it be according to your representation, second paragraph. That should be
Oh, my lord, it's given 211,686 decimal.
Your representation says 856.68 hectares.
Lord, decimal into hectare must be that.
Let this be recorded. Last time. In respect of 856.68 hectares of land in several plots under PS Durgapur-Faridpur and Kanksha, KANKSA, comma, district, Paschim Bardhaman. Stop. SS Natural Resources has been made a party to the writ petition because they will be affected by the order.
Yes. No.
They will
Not
be
made them a
affected,
party.
isn't it?
But they will not be affected. I am only asking for assessment of compensation. So their suit is their suit. No, I am only asking
The
for
petitioner's rival company, let me record it this way. Rival company SS Natural Resources Private Limited purchased 56 decimals of land, which is part and parcel of the leasehold land allotted to the petitioner, for which the petitioner is unable to commence mining operations in the plots allotted to him. The petitioner submitted a representation in this regard before the concerned authority, seeking initiation of the process of assessment of compensation and transfer of the portion of land held by SS Natural Resources. Presentation taken on 21st December 2023. Submitted a representation. Submitted a representation. Has submitted a representation to the concerned authority on 21st December 2023. Tapa seeking which is yet to be considered. Stop. The petitioners pays for a petitioner pays for a direction upon the authority to consider the representation at the earliest. Paragraph. Learned counsel for the respondents submits. Who should consider? The principal secretary.
Second respondent. Second respondent.
second respondent.
The second respondent be directed to consider the representation in accordance with law. Paragraph in view of the above, the petitioner is disposed of directing the second respondent to consider and dispose of the representation submitted by the petitioner dated such and such within 4 weeks from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, in accordance with law. Paragraph the
No, just one indulgence, where your lordship is directing him to consider. Would your lordship be pleased to also record the lease, consider representation and act in accordance with the lease deed? State is a party to the lease. State has covenants.
Yes, very good.
Kindly.
A petitioner, and upon taking into consideration the terms and conditions laid down in the lease deed, executed in favor of the petitioner.
That is.
Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof.
Grateful.
Disposed of which action?
For your lordship rises, my lord, I was in item number 766. My lord, I missed. I was for private respondent number 5, 6, and 7.
You're the private respondent. Give your number.
Lordship, 757, we are on for state lordship and we state lordship. After having a vigil look, we missed it.
For the state. 757.
Lord,
Much of rice. Where were you when the matters were
Lordship,
called? I cannot
after
be-
having a vigil, lordship, what
my
do
lord,
you do?
extremely sorry, my lord.
The matter engaged there and rushed to, after finishing that matter, we rushed your lordship. They don't already over lordship.
My lord, kindly just, my lord,
Matter, sir.
759. Item number 759 to 7.
item number 759 to 765, Lordship, I could not appear before your Lordship. I was engaged in 652, Lordship. Your Lordship,
Appear on the next date, it has not been dismissed.
dismissed for
It's been dismissed.
defaulting.
You are the
Seven-
petitioner.
I am the petitioner, Lordship.
Other side may have been there, I do not know. Yes, other side was there.
Only Lordship, Mr. De was there, Lordship, Mr. Chandicharan De.
So I cannot pass an order in his absence. Take necessary steps. Because they know that it has been dismissed for default. So I
Lordship,
cannot change the order.
they did not give their appearance, Lordship.
I remember.
Yes, Lordship. Mr. J's Junior, Lordship, informed me,
And in
Lordship,
other
that
matters also, there were other response. I cannot, please do not mention these matters.
Lordship, 7 matter, Lordship, kindly.
It's group 7.
Lordship, I will inform Mr. De. Lordship, I will bring
No,
Mr. De, Lordship.
If I allow your application, I have to allow all others also, isn't it?
This is my application.
I am appearing.
পড়ে গেছে। আমি উঠে যাওয়ার পরে একটু কাউকে বলবেন তুলে দিতে। পেন্সিল পড়ে গেছে। আমি পরে বলবো। Mr. Khan is appearing.
Now, practically, I have concluded my submission. If necessary, I can refresh your lordship. Because
I have recorded your submission.
yes.
I find.
Now, Mr. Debray on the last occasion produced one judgment where it is his claim that your lordship has already decided the issue that the permission of the Transport Department, Government of West Bengal or the State Transport Authority is not required for RTA if they want to change any route or any other thing in terms of section 68 of the Motor Vehicles Act. Now, I do not know Mr. Debray will place anything more or not. If Mr. Debray plays anything more or otherwise, I can distinguish that judgment. Mr. Debray will place certainly something because he has to indicate on the last occasion he has given that judgment, but he has not indicated that as to how this judgment is relevant for our case or not. No. Is there exception? The exception to the report we have not filed earlier.
You want to file today? You have served?
Yes.
Mr. Debra needs time. His face says so.
No, we have already served long back.
This case only covered by your lordship order. Purely covered. Lordship, kindly see my report.
Report. কোন রিপোর্টটা? কোন রিপোর্টটা দেখো? দুটো রিপোর্ট আছে, একটা অ্যাডিশনাল রিপোর্ট আর একটা রিপোর্ট।
In the second writ petition, the private respondent has sought implementation of the order.
Yes.
Mr. Khan is appearing in this matter.
May I submit to? Yes. Lordship, kindly turn to page 43.
47 now?
43, page 42 first.
Of writ petition?
Of writ petition. This is the first initiation. Why the regulation must take place? Took place. Petitioner moved a writ petition. Consider order was there. How can we appear?
And I believe Mr. Debray cannot appear any further in this matter. He was appearing for the petitioner at the first instance of the matter.
Was appearing for the petition?
Yes, page 42. It was also not noticed by me. Just now he has brought it, that's why it come to, I just asked him. He told me, just now I have seen it, now I think, how can I appear?
How can I just?
You cannot actually appear.
No, I cannot.
How can I appear?
How can I?
Because he has moved writ petition. On the basis of that writ petition, entire thing has been initiated.
This was in fact the first writ petition which
Yes,
initiated
first
the
writ
entire.
petition.
The entire thing. That is why I have apologized. This is not.
You used to appear for petitioners at that time.
Yes.
I am
Everybody, except Mr. Khan.
2006.
2003, except Mr. Khan. Mr. Khan was appearing for the state till 2014, 2011.
So I get to recuse from this matter.
Definitely. Right?
So you have to serve a fresh notice.
But I have to serve fresh notice, or Mr. Debray will inform to the government.
I inform to the government.
You will inform.
He will inform to the government and return
For
the
appointment of someone else.
someone else.
That will be better.
They will appoint.
It is.
ওটার জন্য আমি তোমার দেখালাম যে আমি আগে তোকে দেখাই না তোমার জুনিয়র তো দেখাই জানি না দেখাতে পারবো না আমি তো বুঝে আমি তো ওটা দেখেই তো পসিবল আর
এত তুমি এগিয়ে গেলে
740 of 2006. Filed in respect of the issue involved in the present petition, comma, Mr. Debray had appeared for the petitioners. Paragraph in view of the above, Mr. Debray seeks to recuse, R-E-C-U-S-E, recuse from the present petition. And further submits that he shall intimate the same to the same at the office of the learned government leader for appointment of.
হ্যাঁ আমি কেউ দেখিনি আমি যে আমি হট করে আমার চোখে পড়ে গেলে কি ব্যাপার
আমি তো প্রথম থেকে ছিলাম না
Some other learned counsel to represent the state.
প্রথমে ইনিশিয়েশন তো তোমরা অপ্রুভ করেছি
Paragraph in view of the above, comma, the matter is adjourned.
আমার চোখেই পড়ে না
Paragraph, let the matter appear under the same heading on
some days is required
20th May.
20th May, or you also shift it after the vacation, because 20th May on the knocking of the vacation, because this is the only 4 days are there.
24th is the last day.
24th, in between,
At least.
in between 23rd is a holiday.
Mr. Chatterjee, let it remain. Let us see who appears, what happens, let us see.
Your lordship is returning from the circuit in the month of, on 6th of May.
6th, yes.
On 6th. Then your lordship can place it on 17th.
Very, very.
17th, because 20th is a very bad day.
very bad day
Very bad day. What will happen, we do not know.
17th করুন আচ্ছা একদম শুরুতে করুন exception used by the petitioners to the additional report submitted on behalf of respondent numbers 2 to 4 is taken on record. First one.
আমার আর একটা মামলা আছে ওদের খানি ছিল
Next.
That we go. My lord, kindly peruse the last order, my lord.
Who is the fourth respondent?
Fourth respondent is the Jharkhand authority.
next matter next matter there is a two matter
This matter, Mr.
Yes,
Khan,
that-
you are appearing for the
Yes, Mr.
state.
Khan.
Yes.
We have
And
submitted
where
for,
is
I am
Miss-
superior to
Miss
Mr. Khan.
Aishwarya Rajeshri, where is she?
Number 12 minor.
Where is the report? She wanted to submit a report today.
Any matter for passport.
Passover is not possible in this court, you are aware. The second respondent has submitted a report. Do you want to use an exception to it?
No.
No. Let me grant up an adjournment because she's not there.
STA Jharkhand has to file a report. That's what,
for
for that,
main
act
grievance
second,
against-
brother, act second. For that, she prayed for time. Your lordship granted time. Unless and until the Jharkhand gives the report, Lord, perhaps it will not be visible.
So that's why I intend to adjourn the matter today.
I have main grievance against the STA West Bengal. Since my lord counter signature has been withheld by the STA West Bengal.
It has
My lord,
been rejected.
renewal,
Not
my lord,
That will at the time of hearing will argue.
my lord, extension has been granted by the STA Jharkhand. Letter has been issued by the STA Jharkhand without adhering the clause 2H. And my lord, thereafter the permit has been renewed by the
This is all
STA
repetition of
Jharkhand.
fact, last day also.
Yes, but the Jharkhand STA wanted to come back with a report. Let them
Right.
come back.
Right. Let them come with the report.
My lord, so far the other grant of permit is concerned on the self-same aspect. My lord, your lordship sought for the report from the ST West Bengal that why that permit of the Om Prakash Gupta has been granted without taking prior consent. That has not been whispered in the report, my lord.
Please come back on 9th May.
9th May.
On prayer, please be ready with the report at least on the next occasion, right? On prayer of the fourth respondent, the matter is adjourned. Paragraph let the matter appear under the same heading on to 9th is a Thursday. 10th.
And my lord, so far the
Ten-
my lord, so
10th
far
May
the
it will
report,
appear.
my lord, so far the report concerning the permit of the Om Prakash Gupta, but that has not been spelled in the report, my lord.
Please look into this issue.
What-
Because you have granted to another person without the prior.
we shall deal with all the but that has been spelled in the report.
আরে বাবা যেদিনকে হিয়ারিং হবে সেদিনকে বলবো তো আমরা।
Next.
দাদা এটা
Mr. Mukherjee is appearing in this matter. Your supplementary affidavit is ready?
Fine. Supplementary affidavit. Supplementary affidavit টা দিয়ে copy service করে দিই।
Oh, Babughat.
মার। আরে কোনটা?
Have you served the copy?
কোনটা শুনে কোনটা? আপনার this.
Mr. Debra, you have received. Now you are serving.
Your lordship, unless your lordship.
Or unless
This order,
দিয়ে দেয়
the
জন্য না।
order is not in that way that this advance copy of the supplementary.
তো
affidavit.
দিতে হবে
So,
order।
but I am on this technical issue. But let it be any other day taken up because I am giving the supplementary copy. I'm not on that. This has to be taken up today. But I'm not on also.
You cannot be on that, Mr.
Well,
Debra.
I'm not asking even anything.
Mr. Debra, you want to go through this or make your submission today?
Any other day, we lordship. Any other day. Right.
Supplementary affidavit submitted on behalf of the petitioner is taken on record. Paragraph copy of the affidavit is made over to learned counsel for the respondents in court this day. Paragraph on prayer of the respondents, the matter is adjourned. Paragraph let the matter appear under the same heading on 13th May.
13th May. Huh? ঠিক আছে। The second কত item? 717.
Next.
On the next is also same matter.
This is also same.
Mine.
Your supplementary affidavit?
Mine I did.
Just a minute.
Mine I am. Your lordship में
The issue is also the same. So
same issue मतलब same day your lordship same day.
Same order.
13 ঠিক আছে।
Yes, I am appearing for the petitioner lordship.
Yes.
On the last occasion, I was supposed to give the affidavit in opposition in respect of the intervention application. And here is the,
Who is the intervenor? Mr. Mukherjee is appearing in this matter again.
Mine.
and here is the affidavit of service. And within 1 week, there was a direction to file the reply and that has not been received yet.
But just day before yesterday when I received the copy from my advocate on record. With me,
only 1 week time may be given so that I can file the reply. In the meantime, I can file. When I advance copy, I will serve.
Lord,
Let him come back with the reply. Please serve an
My lord.
advance copy.
My lord, your lordship can
Can one-
record it that I shall serve a advance copy also.
Why do I need to record?
My lord,
It is
no,
your
my lord,
subject.
that's because
Lordship, I
Affidavit of
beg
service.
one indulgence except 17th and 18th. I shall be out of the council.
Of this month, it will be in
Of
May.
this month.
It will be in May, not this month.
Lordship, 3 months it is going on. We are just lingering on the
Yes,
process.
I'll go for a circuit bench after that, so I cannot fix.
short time.
Affidavit of service and affidavit in opposition submitted on behalf of the petitioner are taken on record. Paragraph learned counsel for the intervenor seeks accommodation to use the reply to the said affidavit. Paragraph, let the matter appear under the same heading on 14th May.
14th of May.
Next. Yes.
reply opposition. কোথায় আছে? মানে the issue your lordship kindly state কত এটা? কত ঠিক আছে? So straight away come to 34. Mala, this is under challenge in this writ petition. Earlier lordship, this my lord.
I just wanted to see the earlier order. There was an earlier writ petition where an order.
Yes,
has
my
been
lord.
passed.
There was an earlier writ petition where your lordship is pleased to direct to submit a comprehensive representation recording that the renewal as well as the replacement before the authority that has to be considered upon giving an opportunity of hearing.
Yes.
To the thereafter these decisions comes on. My lord, your lordship, this matter also taken up by my lord earlier, this particular writ petition, where your lordship kindly come to page 34. That is yes. The order impugned.
Yes.
I have only two aspects of this. One is this, the what? Fifth column, fifth para of the impugned decisions, that whereas as per extant acts and rules, it is not permitted to buy a vehicle unless an offer letter or replacement order is issued by the concerned authority. One is this as other part or not on that. The expiry that I have given, I have explained. After the expiry of the permit, one can apply one can apply for renewal of permit in terms of section 81. Section 81.
West Bengal rules. Motor vehicles.
Section 81, subsection.
West Bengal motor vehicles. Motor vehicles rules.
May I? Rules.
Yes, you have referred to the rules also on the earlier date.
Yes, ma'am.
Section 81(3).
Section 81(3). One can apply minimum after the expiry.
State rules.
This issue is that whether this that I have explained in my petition as well as the comprehensive representations, whereby I was prevented from making the applications within the period, and that is there. And my lord, also my lord, the power of the authority is there also. That is under rule.
Yes,
But the power of the authority that is under rule 151.
that's why I'm looking for the West Bengal rules.
May I hand over the my lord, copy of? My lord, may I hand?
এইটাতে এই বাঞ্চটাতে হবে এই যে ওই একদম আচ্ছা yes 151 schedule E3.
Rule 151 is in respect of renewal. Rule 151 is in respect of the renewal of permit.
E3 is the late fees.
Rule 151 in respect of renewal of permit. As your lordship will find that 151 application for renewal of a permit or renewal of counter signature, both. Similarly, the fees prescribed in Schedule E3. Schedule E3
is the fees.
The fees. There your lordship will find that Schedule E3 clause 5 V. Beyond 90 days, but subject to specific approval of the regional transport or district transport authority. There is a scope that even beyond 90 days, the authority can consider if it founds that the reasons which prevented the applicant to make an application in terms of section 81 subsection 1, then if they are satisfied, that satisfaction has to be in their resolution that they are not satisfied on this ground.
Yes.
That was one aspect. Second, my lord, replace it down. I will also kindly see, whereas as per extent of acts and rule, it is not permitted to buy any vehicle unless offer letter or replacement order issued by the concerned authority. Now we will also kindly come to again rule. First of all, my lord, the act says Act is very small, 83, section 83 Act, so far as the replacement is concerned.
Yes.
Section 83, a replacement, the holder of a permit may, with the permission of the authority by which the permit was granted, replace any vehicle covered by the permit by any other vehicle of the same nature, whatever. Remember that was not the issue. They are saying unless the order passed to purchase a vehicle, you cannot. Now, we'll kindly come to the rule 153. Rule 153, West Bengal Motor Vehicle Association.
10A, yes.
Sub-rule 1, clause 1. But there are two options. One is this, if the holder of the permit already having in possession of the vehicle and a registered owner of registered the vehicle, then he can produce. Your lordship kindly see, if the holder of a permit to a particular vehicle by specifications of the registration marks desires to at any time to replace the vehicle with another, he shall forward part A of the permit and apply in writing to the transport authority by which the permit was issued, stating that the reasons why the replacement is required, and shall, if the new vehicle is in his possession. Now, will also kindly appreciate one thing. They are saying that it's required pre-fact to have. Now, unless they ask to produce a vehicle in replacing the earlier one, I cannot. So, that is not the even rule. The Act is nothing about this, but the rule is specific that in two things that there. One is if the second clause 2, if the new vehicle is not in his possession. Here, there are two options is there. But in my case, the present case, that the petitioner is in possession of the vehicle, he produced. Now, these are two aspects. And the other is this, the one C86. So, 1 C 86, they have taken that though this has not yet been cancelled. 86 section 86 says the cancellation and suspension. In my C says if the holder of the permit ceases to own the vehicle covered by the permit. So that was not at all no notice. Because of these reasons, then no notice has been issued. Anyway, even if I gave the explanation, what the reasons that this vehicle was, how it has been seized by the bank, Contai Cooperative Bank, and this matter is, this issue is pending before the first court, HON'BLE, first court Midnapur.
They have placed reliance on 86C.
That is there. 86C is this, the holder of the permit ceases to own the vehicle covered by the permit. Now they are even then they have to, but this has not yet been cancelled. They are saying that liable to be cancelled. For Lordship kindly see. So that has not yet been cancelled. One is aspect, this is, and the reasons for vehicle was not in the reasons I have given in my representation, that the vehicle which has been seized by the Contai Cooperative Bank owing to default in payment, and the matter is pending before the learned first court Midnapur, that I have annexed the document which is still pending in my representation, as well as my document I have annexed there. And no notice, so far as that is not, that has, the stage has not come, then no notice. Your Lordship will find the subsection, sorry, but that section, the proviso is there, provided that no permit shall be suspended or cancelled unless an opportunity has been given to the holder of the permit to furnish his explanations. So though I have already given the explanation, even if they have to make a notice upon me, so again you have to explain why, what is the reasons, as because. Second is my understanding, but the heading of the 86, the headline, this caption is cancellation and suspension of permit. Now, my understanding, subject to minor's correction, the word used in suspension, normally with cancellation, after this, if they ask me as to why this has to be not be cancelled, then if I explain these issues and if I intend to place, the always it, but the opportunity has to be given. One other aspect is this the permit not for the purpose of the person who is getting the who is holder of the permit. Permit always to operate a transport vehicle, ultimately which give the benefit to the traveling passenger. But the question, if I intend to place another vehicle, so this has to be taken into consideration, and that way they can suspend the permit in operations. But your Lordship kindly see only one, that is the D. 86D is the, in my submissions, 86D. That has not been done here. If the that
D is not.
But that I am saying, this is a questions where authority have a right to cancel the permit because of the misrepresentation or fraud. The permit has been obtained.
May cancel or may suspend. So it is the prerogative of the authority. That cannot be challenged. You cannot say that they should have suspended and not.
And I am not. No. I am not on that one. I am saying that one has to give the opportunity.
That was
then if he satisfy the authority, what is the reasons behind this? The authority can take it as a suspended permit. Then if he thinks.
You were heard on that date when before the order was.
Yes,
passed.
I have given. I've made the representation. I have given all these aspects, that where is the vehicle, everything. Now, my another.
Where is your representation? Let me see.
That is at page. That is at page, my lord. Page 32.
Kill in the name of grandson.
এখানেও সেরকমভাবে কিছু explanation আছে। এটা হচ্ছে কথা। When I'm stated in paragraphs also in the petition,
But where is the consideration of this application, this representation in the order impugned? The order was passed in upon considering the representation,
my lord.
but there is no
But that the findings
consideration in the
and
order.
your lordship, that's similar. Your lordship kindly appreciate one thing. The authority, but the statutory body, being an administrative authority or the constitutional authority, must have to consider the relevant issues which has to be considered. Whether that has been considered. Those though the authority which from the order impugned, it is not appearing at all. The relevant facts has been considered, or here, rather, the irrelevant issues which has no connection or no nexus with this, that your lordship will, whereas
You have not yet purchased the new vehicle. You intend to purchase the new vehicle.
I already, the loan has been,
Your representation says so.
a loan has been sanctioned, and I think only loan has been sanctioned. I purchased the vehicle, it has to be registered. I purchased the vehicle, but this chassis new, in case of new vehicle, chassis has to be purchased, then it has to be temporary registration, then the body has to be erected on the
Yes.
structure has to be erected. Then I got the permanent registration. I have already purchased, the bank has financed, I purchased the vehicle. Your lordship will find that I have purchased the vehicle in their the order, impugned order. Your lordship will find 1, 2, 3, 4. There your lordship will find Punjab National Bank, paragraph 4.
Yes.
Punjab
Yes,
National
procured a
Bank
vehicle, yes.
and to Bhandari Automobile, documents of Bhandari Automobiles. But these are the dealer of the Tata vehicles. I have also annexed all this, the sanction letter, the Bhandari Automobile already delivered the chassis.
Let us hear the state, Mr. Mohammed.
Yes, submit it. First of all, my lord, the vehicle covered with a hire purchasing. First, I am not going to entire facts. I am not really going to hire purchasing. First, his duty upon, he has to obtain a no objection certificate from the financer. This is the law says, lordship kindly see 51(6), section 51, subsection 6.
Yes, 6.
Lordship got it. The registered owner shall, before applying to the appropriate authority for the renewal of permit under section 22 or the issue of duplicate certificate registration under subsection 22, as a new registration under section of removal of the vehicles where another state or issue of no objection certificate under section 22, change of residence, all of their alteration, the person whom the registered owner has entered into the said agreement, such person being transferred for the issue of no objection certificate. Then, on 7, within 7 days of the receipt of the application under section 6, the financer may issue or refuse for reason which shall be recorded in writing and communicate to the applicant to issue the certificate of registration, and where the financer fails to. Here, my lord, he has not made any application before the financer for obtaining renewal of the permit. Then, my lord, lordship, I am coming with one also.
He wants to place the second vehicle.
They
Permit
cannot.
Permit is valid.
Permit is valid, maybe.
So
But
renewal
here
of permit is not necessary.
Renewal of no objection is necessary. No objection from the financer is necessary because vehicle covered with hire purchase agreement. 51, 7 and 8 lordship, 51(8),
No
Lordship, and
objection is necessary for the contingencies laid down in 6.
6, 7, 8. Lordship, kindly go to the 8 also.
Where does it say that
Section
for
8,
change of vehicle, no objection is necessary?
Section 81 also. Why he changes vehicle, my lord? They are using non-payment of then my lord, section 51 does not come in the picture. It is special provision, section 51. For hire purchase agreement.
The petitioner is not.
Contact cooperative bank, he has finance, sir.
Where is the provision for a no objection certificate for changing the vehicle? He wants to place a new vehicle instead of the earlier one.
He has to renew first, then renew. Renewal. Because 21st, 2021, the vehicle has been expired, permit has been expired. He has to renew first, then replaced. How can I renew? Unless he obtained no objection certificate, produce the no certificate from the financer. Lordship, kindly see my 8, 51(8). The registered owner shall, while applying to the appropriate authority for the renewal of any permit under section 81 for the issue the duplicate certificate of 2014 and the assignment same thing is there. 6, 7, 8 same. He has to produce. Unless permit is renewed, only invalid permit cannot be replaced. January 2021, permit has been expired. Then, my lord, the authority came to learn that there is contact cooperative bank, there is a hire purchase agreement, they failed to repay. That is why, my lord, his vehicle has been seized and title suit is pending before the landed court. That is the landed court below. Section 51, my lord, is a special provision regarding hire purchase agreement. If any vehicle hire purchase agreement, that is covered under the section 51. It's special statute. Nobody disobey this provision, my lord, regarding hire purchase.
Have you dealt with his representation in your order, in the order impugned?
Whereas the permit was expired and transferred to the petitioner they had produced a vehicle name of grandson, Sheikh Robul Islam, grandson, and submitted documents on one sanction of credit facility documents in the name of Sheikh Robul Islam, issued by Punjab National Bank, others bank, no contact cooperative, others bank, in the name of grandson. To Bandhan,
There is no difficulty.
the variations where as well as the order is held by council authority. Then, my lord, lordship kindly say 86 1C, 86 lordship kindly.
Motor Vehicles Act.
Motor vehicle.
86.
Center.
86.
86.
Yes.
The transport authority which granted the permit may cancel the permit or suspend it. C. if the holder of the permit ceases to own the vehicle covered by the permit. Here, my lord, he has not applied since 2000, January 2021 till 23.
The permit expired on 21st January 21.
Expired on 21st January.
Yes.
21st January 20.
Twofold press, place renewal of permit
And lordship
upon
valid and
placing a new vehicle.
upon 81.4 lordship valid. 81.4A. Lordship. The lordship, lordship got it. 8.4. The regional transport authority or the state transport authority, as the case may be, may reject an application for the renewal of a permit on one or more following grounds, namely the financial condition of the applicant as evidenced by insolvency or decrease for payment of debts remaining unsatisfied for a period of 30 days prior to the date of consideration of the application. Here, my lord, he has not repaid his loan. That is why my vehicle has been seized. The question of earlier vehicle has been seized. That the question of further renewal does not arise because there is no vehicle in the eye of law.
He is placing a new vehicle and asking
New
for
vehicle and
renewal.
asking fresh application. He has to file a fresh application. That has to be considered. He has to
Mr.
file a
Devra,
fresh
that
application.
is, I think that is not the law.
81.4 lordship kindly see. He referring 81 for renewal. I am referring 81, 81.4. There is a bar. And thirdly, my lord, petitioner want to transfer his vehicle. Not in his name, transfer his vehicle. That cannot be possible. That cannot be permitted. 86 possible. That cannot be permitted. Transfer his grandson.
Not transfer. He is taking the vehicle in his grandson's name. His grandson is buying the vehicle.
No, not his name. Grandson's vehicle, grandson's name. Can it be permissible, my lord?
Is there any bar?
Yes, grandson has to apply afresh. Grandson is a 22 years, I have just done.
Yes.
86, so one, there is a bar. If the holder of the permit ceases to own the vehicle covered by the permit,
Yes, Mr. Mukherjee.
Lordship kindly, with great respect to my learned friend, senior friend, when your Lordship kindly come to section 81, as your Lordship, my learned friend shows that section 81, and the part of the consideration.
One issue
86.
is, Mr. Mukherjee, the new vehicle is not in your name. So how can you claim renewal in respect of that vehicle?
But you subject to my lord's correction.
The vehicle will be in your name, isn't it?
These, I can say, these petitioner is of about age more than the permissible limit by which he can get the finance. This is
He
can get the financer, whether the banks, nationalized bank or the private financer. They can only extend the finance up to a age limit. So the person whose name is the permit, he is not in that age to get the finance. One is the aspect is this. I am not on this that Whether this can be considered if there is any law or not, that I am not. But one reason is this, for which he has tried his development, but none of the nationalized bank or the private finance allow to or extend the finance. Nevertheless, he thinks to purchase the vehicle to continue the operation in the name of his grandson, and that your lordship will find in their findings also there.
Mukherjee, there may be a change of vehicle, that is permissible. But the second vehicle also should be in the name of the permit holder.
Well, that
It is in the name of the grandson.
the grandson can.
The permit holder should be the same.
The permit holder is here. I am on
Not
this.
the same.
No, permit holder. The permit holder is applying for renewal. And the I am right, subject to that. And while he is placing the vehicle by replacing the earlier one, which was in his name, Now, as because he is failed to obtain the sanction from the
Can
bank.
that be a ground for consideration of the authority?
No, that your lordship kindly appreciate whether
Please
at all,
show us
I am on this, whether this has been dealt with, and on that score this order has been passed.
Please
Nothing,
show me some provision.
No, that has not been there. Let them. Where they have stated in their order that this is also one of the reasons. No, your lordship kindly come on
have stated
to
that
the
there was no
findings of the
vehicle.
authorities too. One is 86 1C, 86 1C. Other is this offer letter or the replacement unless this.
86 1C.
Number the 86 1C, your lordship kindly come to in that even. 86 1C. Now your lordship kindly see 80. Before that, my lord. One point has been, one grounds has been taken by my learned friend, subject to my lord's, my learned friend consider 81. He has taken also 81, the renewal part. There he took the subsection 4. 81 subsection 4. Clause A. Though it is not in their reasoned order. As because it is before the court, your lordship can take up my learned friend took this point that the regional transport authority or the state transport authority, as the case may be, may reject an application for renewal of a permit on the one or the more following grounds, namely. Now then he took this, that the financial condition of the applicant as evident by insolvency or decree for payment of debts remaining unsatisfied. Now,
this is a different issue
my
altogether.
lord, then my learned friend took this point because neither the decree passed where I have been declared as a judgment debtor, nor the insolvency certificate had been issued, or the insolvency proceedings has been
Matter
initiated.
squarely falls under 86C.
86C, that also your lordship can see where the 86C. But in respect.
Why don't you apply in the name of the person who has purchased the vehicle, the grandson?
Then I have to take instruction. Huh?
Status says how did he ask?
Which? I have to take instructions and I will come again because
these are all admitted facts.
No,
the
this
vehicle was taken away.
Let me,
expired in the meantime.
My lord, let me, on that.
A permit without a vehicle is good ground for cancellation.
No, that yet not cancelled. The lordship kindly appreciate by 86. Now kindly 86, then 86.
Yes.
First 86, first.
Cancelled or suspend. You are on that.
No, that is the caption. Skip over the 86 proviso that no permit be suspended or cancelled unless an opportunity has been given to the holder of the permit to furnish his explanation. Now we'll ask you where it has been given.
That is given. You have been heard by the authority.
No, not on the score. Not on the score that 86 notice has not been issued. It has to be, my lord. If I go, technically, if I go then they have to issue the notice under section 86 why your permit should not be cancelled on this ground. So that has not been even the lordship kindly appreciate.
There was an order of the court. The court directed the authority to consider the representation
They are the
on the same issue.
So
And
that has
after
not
that, a notice of hearing was
whether from this order it appears this permit has been cancelled.
Yes. It says it's liable to be cancelled.
So that has not yet been finalized. Let them say, let them consider, let them
Mr.
say that.
Debra, liable to be cancelled is not cancellation.
My lord, your lordship.
So has it been cancelled?
Question of renewal cannot be allied. Question of renewal at present cannot be allied. First of all, there is 2 points, my lord. There is 2 points. First of all, my lord, 86(1)(c) is there. Next, my lord, 81(4) is there. And 51(678) total bar for renewal. Because he has obtained a loan, he has not produced any no objection certificate. Then, my lord, same language is 814 also. Lordship kindly see. Financer. He has not made a party to the financer also, yeah.
51(6) is with regard to something else, absolutely.
Renewal.
No, please find out. Please show me where it is renewal.
51(7)(8), Lordship kindly see.
For renewal of a permit under section 81.
My lord. 81. There is a bar. If he applied for financer, not communicate, then my lord.
So this NOC should be in respect of the new vehicle, the second vehicle.
Second vehicle now.
Because first vehicle has been taken away.
Taken away, maybe taken away. Then my question of my lord, second vehicle in the name of grandson. How can it is them no vehicle?
There are several anomalies.
That I have seen, but your lordship kindly appreciate one thing. Again and again, my learned friend is having 81(5)(4). But 81(4) cannot be applicable in this case. 81(4) the decree. No, civil decree. Then there I have to declare the judgment data. So far my understanding about the civil law is concerned, one cannot be unless I declared insolvent. But what is he saying? If a loan is due, that cannot be said to be decree has been passed against me.
Why not?
I have a judgment.
Why not no objection?
What is the language of the statute?
Even if 81 is given a go by, let us
I am not on
81.
that. But he is taking. I am not on that. This cannot be applicable.
Let us take it that 81 is not applicable.
No,
but under 51(6), you need a no objection.
Grateful, madam.
From the
kindly, now your lordship. Rightly, your lordship has hold. But the thing is this: when I have stated everything in my representation that this has been taken away by the financier, the question of asking NOC, even then, if they decide to that on that score, whether the order has been passed in that score, that you haven't yet received the or applied for NOC, that's why. Where is this from the order itself not appearing, my lord? Order itself not appearing. Whatever my learned senior friend is saying, that is afterthought. Let them say all these things.
This is the law.
If I send this for reconsideration,
they will take this point.
And
but I will.
Take this point, and an obvious result will come.
But that result, yes. Then I will come back also.
Instead of that, I think it will be a better solution if the grandson applies for permit.
That only I take the instruction because my client has.
Because you cannot ask for a renewal in the name of some other person.
There are some issues involved in that way because this permit, where lordship will find the permit is from this is the lordship only comes to permit. Permit is at page 23 B, part B. Your lordship will find this is a route in column 3, Balai Panda to Kolkata Railway, sir. Page 23.
Yes.
This is only difficulty if the grandson applies, then my lord the alignment Kolkata railway station via Pingla so and so then where?
LDBT, how LDBT will not be.
Please show me a provision where a permit can be renewed, an existing permit can be renewed in the name of another person.
No, my lord, I am not on.
Change of vehicle, yes, absolutely.
No, my lord, I am not on
Your
that.
new vehicle is, you are on a technical issue, the points have not been considered, all that. But if I send it for reconsideration, the result will be the same.
I am
If you
not.
still want a reconsideration, I can send it back to the authority, no difficulty. But you are also aware that the authority will take these points and reject your application.
Let me take some time my lord, to
Isn't
get
it?
instructions.
If it is sent back for recon, it will not really help your client.
I feel my lord, this issue, but there are other problems is that if
This
we apply,
paper
my lord,
has
if we
already
apply,
expressed his opinion.
but only thing if we apply, my lord, you also can see the permit. Permit is my lord, cover because of this
Any
old.
law, any authority which shows, which supports your claim.
বলে দিলে হবে না তো। মানে I feel মানে the only problem মানে only মানে difficulty or the মানে predicament is that মানে this permit which has been granted way back in মানে 2019.
Yes.
So মানে there your lordship will 2019 there the route which my lord
2016 it was granted.
2016 or 2019 কি
5 years, 2021.
2019 not
No, no.
2016
16.
2016 মানে this alignment মানে I think মানে this if মানে the issue is this মানে the part of the route
Illegal citizen.
covers মানে some restricted zone.
Yes.
মানে if he applies মানে now মানে that at that
No, it says it should not touch the restricted zone. Please see the endorsement.
then মানে even if মানে I haven't the instruction in that way. But my advocate on record is here. Let him take the instruction any day your lordship thinks, I will dispose of. When your lordship will dispose of you. I will not take up any cost as your lordship. But the only thing I have to take the
No,
instruction.
that is fine. But then you should consider these issues also which are put forth by Mr.
As your lordship observe that it is better redelegating
I do not find any
relegating the
provision.
same to the authority. Rather you make an application. I will observe that should be considered in accordance.
Again, it rejected upon the on
No,
these
well, that.
grounds.
I'll take the instruction. Well, I
Help your
Fine,
client.
fine.
It will be rejected again on the same issue, on the same ground.
Because first point is that preliminary point. I have to raise preliminary objection. No. I have to raise preliminary. What is the local standard? In the eye of there is no local standard. Grandson's vehicle. He is convicted.
Let him come back with instructions.
The only instruction that whether he will apply in the name
I'm
of
not
the
recording that,
Well,
but
right,
let's
right.
come
Well,
up with the
yes.
necessary
Well.
instructions. Let me see. Third learned counsels for the parties.
করে দেবে, বলছে তো করে।
The petitioner has assailed the order passed by the Secretary, State Transport Authority, West Bengal.
Apply করে ঝামেলা আছে এবার দেখছিস কেন?
The order was on 3rd October. Third October 2023.
কত বছর? Next matter টা হবে?
Turning down the representation submitted by the petitioner. Submitted by the petitioner pursuant to an earlier order of this court passed on 22nd August 2023 in WPA number 20108 of 2023. Stop. Paragraph. Learned counsel for the petitioner submits that permit was issued in favor of the petitioner in respect of vehicle bearing registration number WB 33C 7786. And the vehicle was seized by the Contai Cooperative Bank due to alleged violation of terms of the hire purchase agreement by the petitioner. Stop. Being unable to release the said vehicle from the custody of the financier / bank, comma, the petitioner applied before the authority for renewal of his permit, which expired on 21st January 2021, and placing a new vehicle registered in the name of his grandson. Learned counsel submits that the representation was turned down on the ground that on several grounds, : the permit expired on 21st January 2021, but the petitioner failed to inform the same to the authority. No, and the petitioner failed to inform and the petitioner failed to inform the authority regarding seizure of the vehicle either prior to expiry of the permit or immediately thereafter. Stop. The new vehicle is in the name of the petitioner's grandson and not the petitioner himself. Stop. The petitioner was not permitted to buy any vehicle unless offer letter or replacement order was issued in his favor by the authority, and also, comma, the permit is liable to be cancelled. Permit was liable to be cancelled according to the in view of the provision laid down under section 86(1) small c of the Motor Vehicles Act 1988. According to the petition paragraph, according to the petitioner, comma, the representation submitted by the petitioner was not taken into consideration by the authority, and no notice under section 86 was issued upon him prior to the impugned order. Paragraph. Learned counsel for the respondents submits that the petitioner's permit was cancelled in terms of section 86(1) within bracket small c of the Act of 1988. Stop. The petitioner the petitioner failed to submit no objection certificate along with his prayer for renewal of the permit in terms of section 51 within bracket 6 of the Act. Since the new vehicle has been purchased, since the new vehicle is not registered in the name of the petitioner, comma, renewal of the earlier permit in respect of the said vehicle is not enjoined in law. The owner of the new vehicle ought to have applied for grant of permit before the authority instead of the petitioner seeking renewal of the earlier permit in respect of the said vehicle. Paragraph, learned counsel for the petitioner seeks to take instructions in this regard. Paragraph, let the matter appear under the same heading on 14th May.
Yeah, because 14th May.
Next matter.
বিপ্লব রায় মানে
না
এটা আমার বই না
পরে 15 দিন পরে এসে ইনসার্ট আমি শ্যামল exception supplementary
You wanted to use a supplementary affidavit in this matter?
yes I have served the copy supplementary copy দিয়েছিলি তো অরিজিনাল affidavit আর জেরক্স কোথায় supplementary
Mr. Debra, your report.
Yes, report, yes.
Exception. Supplementary
Where is the supplementary affidavit?
Supplementary affidavit and subject one of my juniors has misplaced the supplementary affidavit in original. Though copy has been served up.
Copy has been
It's not
in yes, copy has been some even my copy also not the all these things yesterday. I think and against the report that exception has already been malad.
Exception?
Yes, to the report of.
You want to file an exception to this?
That has been served also.
Where are they?
It is supplementary.
Everything given to the authority but not to the court.
No, exception is with me, my lord.
Yes.
Exception is with me.
So will you file the supplementary affidavit or
They have given the exception as well as supplementary.
No, only two, supplementary. In supplementary, Osif has granted leave to file the supplementary because of the facts, the SDU has given, asked to requisition the vehicle, which has already been declared by petitioner's vehicle, which has already been blacklisted. Even that in election, this ensuing elections, the SDU has requisitioned the vehicle. Well, that only two documents I have annexed in my supplementary.
Oh, he has not paid. He has not paid the certain amount during that period. That is why he's
No, it's a 15-year-old vehicle. That's why it was.
Oh, no, after 15 years. Sorry.
It was blocked.
Sorry, another.
Documents
15 years old vehicle. That is why that is blocked.
Only these two things. এটাও দিয়েছিলি কি এটা কি ওতে লাগানো নেই এটা তো এতে আছে supplementary I have annexed two documents. One is 2 pages. One is this a notice from the district magistrate election cell.
That is another expensive.
So only that part I have annexed in my supplementary, showing that
If
the
you
legal.
do not want to file, let it not be. If you want to be only on this, on the writ petition,
Need not be required to, because only to show that even this vehicle is blacklisted, it has been requisitioned.
it is the SDO's mistake. The petitioner cannot take advantage of it.
No, I'm not on that one. I wanted to show your lordship. On the last occasion, I placed these documents.
That
Your
is
lordship
admitted.
granted me leave to so that it can be
Yes,
recorded.
but you have not
My
filed.
lord, mine. Only I have given the exception also to their. Your lordship, two things.
The only issue is KMA area 15-year-old vehicle.
Now, my lord, right. My lord, on that score, my lord, I am not on that. Your lordship will find in their report, two things has not been dealt with. One is this, my lord, in their report, the last para.
Give me a
Sorry, para 14.
Yes, para 14.
Para 14 of their report. So, my lord, this is admitted by them. So, one part is this, my lord, I am not on.
Yes.
This is, my lord, continuing. Now, my lord, those vehicles are not blacklisted. Whatever be, my vehicle has been blacklisted on the instruction of the State Secretary State Transport Authority, and it has been blacklisted because of that only, so that I can operate outside the KM area, because their statement in their report that if it is outside the KM area, there is no bindings. So that I can operate the vehicle after obtaining the reserve permit for any reserve purpose, or for a temporary, or for occasions. So outside KM area, how can I get the permit if the vehicle is already blacklisted? I cannot pay the taxes. I am not able to pay the taxes. I am not able to pay the insurance. So everything has been stopped. That has
What
to
is
be
the rule for
lifted.
15-year-old vehicle? They can fly outside
This
the
has
KMA
been
area.
there,
Yes.
Yes.
Outside the KM area.
So that part has to be, that should be
Contact courage.
না না ওটা স্টেজ আমি চালাবো না, আমি যেহেতু ওই গাড়িটাকে অন্য
Oh,
জায়গায়
তাহলে তো
পারমিট নিয়ে চালাতে
that
পারবো
is, well, that is decided by the authority. His permit is stage carriages. He converted to contact carriages. He applied before the authority for contact carriages.
This not this authority. I can apply for before the regional transport.
Yeah, before the regional transport.
For reserve issue, I can outside the claim. But if it is not lifted, the blacklisting.
Blacklisting cannot be listed. If you pray before the authority that I am not operating vehicle, I am supposed to undertake.
My lord, I undertake. My lord, I undertake. I will not operate the vehicle, that I will undertake. I will not operate the vehicle within the KMA.
On the strength of the permit.
What does this mean? Not to be transacted, NTBT?
Not to be transacted. No transaction will
Is
be.
that so? That is blacklisting.
That is blacklisting. No transaction.
Transaction with regard to tax.
Regarding taxes.
Even the insurance or others. All the government revenues.
Because all other documents are valid except the insurance. Insurance, pollution, these are all expired. These
কোথায় আছে ওইটা ব্ল্যাকলিস্টিং করলে পিটিশনটাতে আছে তো অ্যানেক্সার আছে তো
tax is valid up to 15th April 2024.
But that not on the ground, these are all been expired. But on the ground, the instructions which came from the sector, yes, that is there. Why it has been blacklisted? Because of the direction.
That has to be.
No, I am not on that. But not on the ground that the pollution.
Bound by the High Court's order and Apex Court order.
So shall I record your undertaking that you will fly beyond the
my lord. My instruction from the client itself is there so that he can
not on the basis of that permit, my lord. Permit will cover.
Yes, not on the basis of that permit. Yes.
It has not applied on
yes,
the
basis
basis
of that should.
So you have to issue a fresh permit.
Fresh permit outside the KMA, and that not by the STA.
That is
yes,
this is
the permit. This is the
So
permit.
you have to apply for issuance of fresh permit before the
regional because yes. Then how can I? Because the vehicle is yet blacklisted. How even that I cannot.
Yes.
With a blacklisted vehicle, I cannot.
The vehicle be released with the blacklisting order be withdrawn. He undertakes to apply for a fresh permit
before the regional
transport.
Yes.
He undertake that not to fly.
Not to fly on the basis of that permit, which has already.
On the basis of that permit, he is not allowed to fly.
submitted by the respondents and exception
যেটা আমার
thereto
থেকে নিলে হবে।
submitted by the
আমার কাছে-
petitioner are taken on record. Paragraph heard learned counsels for the
এর আগের
purpose.
চুক্তিটা যদি আগে নিয়ে রাখতো তাহলে আগেরটা
The petitioner's vehicle has been flagged
তাই তো,
as
ঠিক আছে?
inverted comma রাখুন not to be transacted. Not to be transacted, inverted comma closed, by Murshidabad RTO on the ground that the vehicle is more than 15 years old and was lying in the KMA area. Kolkata Metropolitan. KMA area, A type area. KMA, Kolkata Metropolitan Authority. KMA. The petitioner undertakes to fly the vehicle beyond the KMA area upon obtaining fresh permit in respect of the vehicle from the from the concerned regional transport authority. Paragraph, in view of such undertaking, comma, the
Lordship kindly record another thing, he is not to operate on the basis of his existing permit, because that is valid up to another 1 year.
Madam, that's
Annex
in view
T1,
of
my lord, page 15. Lordship can record.
15 is
Page
the
15, 1-5,
existing permit. Yes.
existing permit.
In view of the said undertaking, comma, the order impugned, flagging the vehicle as inverted comma not to be transacted, is set aside and the vehicle is released from the order of blacklisting. However, comma, the petitioner shall not ply the vehicle in terms of the permit issued in his favor on
Page 15, my lord.
yes, the date of issuance.
Date of issuance, my lord, that is 15.
The permit.
Permit, my lord.
Permit is
90. I think it's 1990.
Permit is of 95.
95.
Read
Lordship, at the top right hand side, PSTP number 1 of 1995. 1 of 95.
Issued in
Of
his
95.
favor
Way
on
back.
4th January 1995. Stop. The petitioner is at liberty to apply for fresh permit before the concerned RTA for plying his vehicle outside the KMA area.
Right.
With the above observation, the petition is disposed of. With capital and capital.
ওই তো বলে দিয়েছে। This should be from the computer itself because this has been locked in the computer.
So once it is released, it will be automatically released. I've set aside this order on your undertaking.
But the respondent number 5 directed because this blacklisting.
I have not directed anyone. I have only set aside that order of blacklisting.
Set aside করেই
So Debra will give necessary instructions to his clients.
I'll give it.
Next.
I'll give that.
Consent.
Well, in this matter, I can on the other petitioner. The last occasion the matter was called. The Sina appeared on. Yeah.
And I am appearing in this matter.
Maybe past because
Mile.
e-rickshaw, because obtained the proton certificate and the 13 January 2002 and 13 July has been assessed in the writ petition. So a similar order may be passed.
No, no, but a similar matter is pending, same cause of action.
No, so that in the last one, I told.
Subsequently, I found
Separate cause of action.
But the issue is that, but that is not in respect of the registration. Here he has asked for the registration of the e-rickshaws. There he object the, oppose the unauthorized operation of e-rickshaws.
Yes, sir.
Then I have gone to, this is a voluminous writ petition, then I have gone to, সেটা কোথায় গেল? But this order.
এই তো ডিসকাশন ওকে দিয়ে গেছে এই অর্ডার করে দিতে বলেছে
এই অর্ডারটা কোনটা?
This is the same order.
Same order. Kindly, the order, the writ petition number 25931.
5931.
সিভিল অর্ডার
Same order.
তো ডাউট কিছু
আরে আগে বলেছে না আজ বলবো
ওটা
আমি
শক্ত এটা দিনা
It is submitted on behalf of the private respondent that the earlier writ petition referred to being WPA 26508 of 2023 and the present writ petition are on different and distinct causes of action. Are on different causes of action. তারপরে এই অর্ডারটা হবে হলল্যান্ড কাউন্সিল সেম অর্ডারটা হবে। This is the third respondent.
Respondent 3.
Yes, yes.
Respondent 3.
Same order. Shafiq, other order. Yes, next.
I am appealing.
Tax is that he has to apply along with this.
I have given you. Instruction is there, madam.
আমার কাছে নেই।
Same 51-6, not
51-6.
complied.
My lord, that has not been complied with.
এবং bank
Decision has not yet been taken. Let
Yes.
them take a decision, let them reject my.
he has not applied.
Let them reject my. So that I can take an. As your lordship, no decision has been arrived at. I am not challenging any decision, my lord. This is only the applications made there, and they send the notice to the bank. Bank has taken this stand that the renewal cannot be granted, and you don't grant the renewal because of he is a defaulter one. But this is the facts here.
This is the
Now
bank.
let them take a decision by their own, because they are the adjudicating authority. Let them take a decision. Only thing, my lord. Let them
Would
take.
that help you, Mr. Mukherjee?
That I will take. My lord,
Lordship,
because let them take. There is no decision as arrived at, my lord. Only let them take a decision.
This is
Even also observe that that has not been
bank
complied with.
intimated
Even
that
then, my
there is
lord,
no.
let them take it.
There is a
Because they are, my lord, the adjudicating. They are, my lord, the quasi judicial one. Let them take it.
possibility কি reason নেবে
Reject for them.
what reason
51-6 violation is recorded in the order.
yes don't last together
On the-
Mala is
on the-
going to reject the application
Well, let them take a decision. Well, only one thing, well, that has not been.
Our
They are
decision-
not at all taken this aspect. If they say, well, even now, if
They
they say
have taken this aspect, that's why they have written to the
well,
financer.
that application has not been considered by law. Let them take a decision on this
Sir,
aspect.
the
On this
application has
code.
not been disposed of.
No, not that has not been disposed of.
or some kind directly dismissed
That only they let them directly dispose of. Even your lordship thinks like this observe that has not even complied with. Let them take that point theory. So that I can
Where is the application?
this application is at page. That is at
28.
What? And before page 28, it was the application. Fees has been given through the online. That is page 27. Oh, online application.
Backlog entry.
Mr. Devra, I'll just give a direction for disposal of this application.
Only thing.
The petitioner seeks consideration of his application submitted before the authority. No date of the application.
Yes, the date is there. Before that page on page 27. This online application has to be made through online. Your lordship will find page 27. They have received it on 12th of September 2022.
Received by the authority on 12th September 2022. In view of the above, comma, the petitioner is disposed of, directing the respondent number.
Secretary Gorbe.
Secretary.
Secretary.
4. Directing the fourth respondent to consider and dispose of the application for application submitted by the petitioner. Date দিতে হবে না কারণ ওটা receiving date বলেছে petitioner within 1 month. Within 1 month from the date of communication of this order, upon affording reasonable opportunity of hearing to all concerned, including the petitioner, comma, in accordance with law. Paragraph, the decision taken by the authority shall be communicated to the petitioner within a week thereof. Disposed of which act?
Diploma.
On hearing.
Hearing door. I appear for the respondent KMDA.
Yes.
It is an option.
Yes, petitioner.
My lord, I am led by Mr. Smith.
And I am led by, or we are led by Mr. Mukherjee, my lord. In fact,
He's not available today.
sorry,
He is not available today.
he is not well, my lord. I understand he has some throat problem. That is why.
You want to come back some other day?
My lord, I can start, my lord, but I would.
I think it was a record. I have taken a note on the earlier day.
It was heard by your lordship quite sometimes back, my lord. I can try to refresh your lordship. And then, my lord, if your lordship is pleased to keep it sometimes next week, possibly.
Next week will not be possible. You have to come back in May in that case. So why don't you start in May itself? Because I have a circuit bench in between. Till the first week of May, I'll not be available.
May I pray this in that event, my lord, this much of indulgence, my lord. Some precedence, if it can retain its position, it's number 1.
It's being fixed at 3:30.
Number 1. It is marked.
I know.
It's number
Further precedence is not
no,
possible.
no. Let it retain its position, ma'am.
When can you come back? When can you come back?
Any day convenient to the court, my lord. We have no difficulty.
15th May?
Maybe.
Yes. On prayer of the petitioners, the matter is adjourned. Paragraph, let the matter appear under the same heading on 15th May 2024, marked at 3:30 p.m.
My lord, the interim order is till 30th
I'll
April.
extend it. The interim order granted earlier is extended till 30th June 2024 or until further orders, whichever is earlier. Let there be an extension.
So it will appear as marked.
30th June, huh? Marked at 3:30. Yes.
3:30.
30th June at least. Huh. Yes.
Lord, I am for the petitioner. State is not here, my lord. May I serve notice, my lord? Or call back call them, my lord?
It's an old matter. Yes, state is not appearing for quite some time.
Your lordship direct me to call them, my lord. I call them. Let it be Passover for short time. Let it be Passover, my lord.
Passover is not possible in this court. Mr. Bandopadhyay is appearing. I do not find anyone for the state today. State group 1 matters. No one.
Let it be adjourned for today, my lord. I will serve notice to Mr. Bandopadhyay personally, my lord. Let it be written in same position, my lord. I will serve notice, my lord. On next, my lord. In the month of May.
First week only 13th.
13th May.
None appears for the state for the respondents. Paragraph, let the matter appear under the same heading on 13th May 2024. Next.
Well, I am for the respondents.
I appear for the petition.
Urban Development Department.
Now, my lord, I have challenged, my lord, the action on the part of the respondent authorities in, my lord, affixing a signboard in my property stating it to be government land. But that your lordship will find at page 33. No order passed. This is the signboard affixed.
Salt Lake property.
Salt Lake property. Now, my lord, lordship will find the deed, my lease deed at page 22. Kindly takes the lease deed once at page 22. But kindly turns to page 28.
The affidavits are on record.
Yes, yes. Kindly turns to the lease deed starts from page 22. Kindly turns to page 28 once.
You are appearing for all the respondents? Page 22.
22, the lease deed starts. But kindly takes page 28 once. Now kindly sees clause 4. Provided always that if there be any breach of any of the terms and conditions and covenants with herein on the part of the lessee content the lesser shall have the right to re-enter into possession of the demised or any part thereof in the name of the whole. Then, provided nevertheless the lesser shall not exercise the right without serving the lessee a notice in writing giving 6 months time. So my first contention is that this proviso was never acted upon. I was not served a notice in writing giving me 6 months time. Now, I'll just take 5 minutes of your time because to show certain documents which are necessary. Now, this lease deed is dated 28th of March, 1984. Number possession, my father, in the name of my father. Number no, এটা কার নামে ছিল? এক সেকেন্ড, ভুল বললাম। Yes, this was in the name of Jivan Das Bajaj. Now, my lord, Lordship will find at page 32. The father of Jivandas Bajaj, my lord, this is a death certificate, died on 25th of May 1982. Now, my lord, this was a joint family business. But I have stated categorically that after the death of my father, my mother also passed away and she was critically ill. My wife was ill. Without all this, my lord, I did not have the initial requirement of depositing the entire sum and everything. That was not complied with because of all these things. Now, my lord, ultimately the family position was stabled in around 2016. The building plan was sanctioned but could not be completed. In 2016, my lord, I find this signboard at page 33. Now, my lord, now your lordship kindly sees, kindly, my lord, turns to page 34. Immediately thereafter, this is dated 30th of November 2016, my lord. I write to the Urban Development Department that plot number such and such was allotted to me, aged about such and such. The above property, I request you to kindly remove this signboard which has been put up. I'll be obliged for your kind concession for the above request. My lord, no reply. Then kindly turns to page 35. Same again, I say that page 35, lordship will find. I was supposed to complete the construction within 18 months. I have not done that. I have given the boundary wall. I have no issues with regard to finance now. I can make the construction immediately. No reply. Page 37, I again reiterate my request. No reply. My lord, this goes on. I filed this writ petition. Now, my lord, in the affidavit in opposition, my lord, kindly take, if your lordship takes the affidavit in opposition, my lord, kindly takes page 3, what they state. Page 3, my lord, paragraph 3b. My lord, they have stated, it is further, thereafter possession was handed over, kindly see 3c. It is further stated as per clause 26A of the lease deed, the writ petitioner was required to complete the construction within 3 years. My lord, 326A is a violation where clause 4 of the lease deed states that you have to give me a notice in writing for 6 months, giving me 6 months time. So for the violation of 26A, if any, my lord, the notice under clause 4 proviso is essential. That is my first submission. Then they go on to say, kindly see paragraph D, violated clause 26A, not construction made within 3 years. Then, my lord, very interestingly, kindly turns to page 4, paragraph 3H. Well, this is their stand. It is stated that as the clause was lying vacant, a peremptory final notice such as dated September 10, 2007 was issued to the writ petitioner herein invoking clause 4 of the writ to remedy the breach within 6 months, or else the government will re-enter position. It is further stated the above mentioned peremptory final notice is also sent to the Director of Information dated August 12, 2008 for publication in daily newspapers. Then they say I filed the writ petition. My lord, my respectful submission over here is that
So they have given a notice.
they say that. My lord, in my categorical submission upon instruction is that such a notice was never served upon the writ petitioner. And if it was served, my lord, kindly looks at it in this angle. If it was served, whether there was any necessity of publishing in the newspapers. Since it was not served on me, they issue it. Number one. Number two, my lord, lordship will find that even if it was issued in newspapers, my lord, lordships have held categorically, if it is issued in newspapers, what is the modus operandi of issuing it in the newspapers? What newspapers it will be issued in? It has to be one in vernacular, one in English. And first of all, it will be served on. If it is not served, it will be pasted on the premises. Only the notice board is pasted. I have taken my clear understanding that if they can show it has been served upon me, I am out of court. My respectful submission has not been served and possibly this point was ignored. But I was praying that let this be reconsidered. This is a residential plot, not commercial plot or anything. I am now more than 80.
Let us hear the respondents. Yes.
Well, my learned junior friend Malal has taken a point. The writ petitioner Jivandas Bajaj said something about his father. That is why he could not do all those things within such and such year. Well, kindly notes the father of the writ petitioner expired in 1982. And the writ petitioner was allotted the plot in his name in 1984. So no question. That question goes.
No.
It was allotted in his name.
Yes, he is the original.
I am the owner. I am
He is
the
the
owner.
original allotee. not
Sandesh Bhai,
father.
I am the original.
Father died.
No, I did not make that submission. My submission was that since it is a joint.
It's allotted in favor
No,
of
no,
the
then I
father.
said, no, I did not
No,
have the brief
he
with me.
said it was allotted in his
It is allotted in my favor. My submission was that since it is a joint family business, my father was suffering everything, I could not take proper
My
notice.
father expired in 82.
Correct.
Allotment was made in
Was the
84.
leasehold,
In
property
my name, in my name.
Absolutely.
In my
Well,
name.
kindly takes 2-3 dates. Well, 20th of March 1984.
তখন ছিল না তো।
20th of March 1984, it was allotted in his name. 24th of May 1985, possession was given to him.
That accent is sorry. My lord, kindly takes paragraph 5 of my writ petition. Possibly, my lord, possibly I was not correct, clear with your lordship. Kindly takes paragraph 5 at page 4. Paragraph 4 and 5. My lord, I say it was in my name. Then I say joint family business, and after the death of the father, there was a major financial crunch. Family business suffered, and they could not make the two. As a result, I was unable to construct the building on the premises concerned despite best efforts. I say it is in my name.
Well,
This was the problem faced.
Father expired in 82, para 4.
I was in a financial crunch.
Financial crunch in 80, even if for admission, well, I admit that he was under financial. This was taken in 1984. During his financial crunch, he had taken this. 82, father expired. This is 84. Well, kindly comes 28th of March, 84, allotted. Then 24th of April, 1985, possession was given.
24th May.
24th May, possession was given. After 85, 24th of May, 88, 3 years pass. The 3 years restriction is on 24th of May. But for the first time after 1985, on 10th of June 1996, after 11 years, he makes the first representation. I want to construct something. 11 years. We give them a 1 year time in 96. Again, 96, we give them a time. Again, in September 2007, after that is another 11 years. 3 years statutory, they apply to us. We give them 1 year time. They sit tight over the matter for 11 years. Again, they apply to us. Again, we give them 11 years time. That takes us to 2007. Nothing done. And my last notice, which my learned friend is saying, the notice was given on 10th of September 2007.
Where is the notice?
This is the notice.
It's annexed to your.
No, it is his writ petition. My lord, let me check
If
whether.
I had an opposition, it's not an.
Let me check. Let me check once. Otherwise, I'll bring this by way of a supplementary.
Take the opposition.
দেখে নিচ্ছি আমি পড়িনি আমরা দিয়ে দেবো আরেকটা ছোট্ট করে একটা দিয়ে দেবো আর যদি রিপ্রেজেন্টেশনে হয়ে যায় তাহলে তার কিছু দরকারই নেই
সেই না নাম তো পাইনি দেখতে দেখি না
Where is the service of the notice?
Well, that I have to check with them.
Dispatch.
I'll check with them. 2007, I'll get the records on the exactly on that point when this was served upon them, and I'll come back on the next day.
The document of service.
Yes, yes.
If this is served, the petitioner has no case.
If this is served, I'm out of court.
Well, that is right.
So this is the most.
Yeah, I have the copy of this, but when it was.
You can take this back. Please come back by way of a supplementary affidavit.
Well, this is the notice. Well, I'll bring on this.
The notice is here, but
Another
the
one.
service of the notice.
Yes, yes. I'm saying.
It is served.
নোটিস করে কিন্তু পাঠিয়েছে কি
আমি রেকর্ড থেকে আনিয়ে দেখে নেবো দেখে তোমার 10th of September 2007. I'll check it when it was served upon them.
The document of service.
Yes.
You can take this back. এটা ফেরত দিয়ে দিন
এটা তো বুধবার হয় না
সাইন কালীকৃষ্ণ টেকস্ট লেখা আছে এখানে থাকতে হবে
Let him come back with the service. You have to solve the entire issue.
Yes, it's only the point of notice. এটা তো বুধবার হয় না
Adjournment counsels for the parties.
দূর
বলে দেন বলে দিন
Deed of lease was executed.
Well, one more thing, one suggestion which I'll talk to Mr. Bihani. Since it is only on the point of notice, one thing can be done. If they go there, this can be disposed of today itself. If they go there and they see that the notice has been really served upon them, they can see whether only nothing remains anymore. Right?
I don't think that will be correct. Please come back on another day. Please show me the service. The petitioner may not be entertained by the authority.
No, not that. Simply whether it was served on them or not.
A 2007 notice,
yes,
whether it was served, do you think the authority will readily find out the records and show it to the
Well, I have some instructions.
My experience is absolutely
well, I'll ask them for the records. This matter has a
Why don't
different
you
file.
come back on the next occasion?
Yes.
Only with the
pass the
showing service of the primary grievance of the petitioner is that no notice under clause 4 of the deed of lease was served upon him prior to cancellation of his allotment. Allotment was not cancelled by way of any letter. Was it cancelled?
Cancel, we went
I have not received anything. They say
we
that
entered into possession. It is with us. Well, I don't
So
know
if they put
what
up in-
happened thereafter, whether it's
put up
allotted.
the normal system is
But
that
there is no document saying that allotment is
Yes.
cancelled.
yes.
Have you annexed any such document to your opposition?
There is no annexure in the affidavit.
You have only put a board there.
Yes.
Where is the document?
Well, putting a board means re-entering into the possession.
No.
Well,
There
I'll
should
take
be a formal cancellation because there was a formal deed.
I was going to make the submission, subject to correction. But for even my argument is that it was not served. That is, but for argument's sake, if it is shown that this was served, then it says within 6 months you are not doing it, we shall cancel your allotment. Where is the order of cancellation?
Well, I'll check up and
We'll find that out on
I'll
the
place that on record. কবে রাখবে আজকে
list. কি বলো ওটা?
আজকে কত তারিখ হ্যাঁ
কদিন পরে রাখো
কতদিন পরে
হ্যাঁ
কত তারিখ
আজকে 10
বুধবার হয়
সোমবার
Prior to the authority, cancellation cancellation order নেই. Prior to the authority taking over, resuming, authority resuming possession of the plot in question. Paragraph per contra, learned counsel for the respondent submits that such notice
এটা খবরের
was
কাগজে
served
পাবলিকেশন
upon the petitioner by the authority.
ঠিক আছে
Learned counsel seeks to use a supplementary affidavit annexing such documents. Paragraph, let the matter appear under the same heading on
হ্যাঁ তো
13th May.
Monday.
Monday.
Well, in the supplementary list or under the heading hearing?
Under the heading hearing. Or shall I keep it
To
for
be-
orders?
Follow. For orders
Rajiv,
in the supplementary list.
Rajiv. Under the heading for orders.
But I have learned many things from my learned senior friend because he was senior to me in my chamber, father's chamber. So I'm sure he'll throw me out. I'm going to let it retain his position. Oh, he'll have it in for order.
For orders as well.
I'm deeply opposed.
But I beg to appear on behalf of the petitioner. But I appear for the respondent. Let my learned friend conclude his argument if he can. But very short, also will allow me some other day. Because it's a, my lord, the cancellation is under challenge. Yes. For the breach of contract, and on this issue, my lord had occasion to deal with some other matters, and some other matters are hearing are going on.
Only the KMDA? Respondents?
KMDA is the principal
That is
respondent.
the my lord, principal respondent. No, it's relating to the allotment of East Calcutta Area Development Project, not a land. But I will not trouble your lordship regarding the all numerous annexure. Initially, if your lordship takes up once, my lord, page 38, or rather, my lord, page 39. Initial allotment was granted in favor of the present petitioner. My lord, your lordship will get at page 39, my lord, the agreement. Kindly turns over the page 41. Your lordship will get, my lord, the schedule.
Yes.
But this is plot number 1, HIGB category, block BB. But has your lordship got it? Not nearing the schedule portion.
Yes, yes.
This was not allotted. Subsequently, kindly my lord, turns over the page, comes to page 44, annexure P7. Because this, what I have shown before your lordship, that was executed sometime in, my lord, 1993. Subsequently, my lord, in page 44, my lord, they have informed that I have shown before your lordship the allotment of plot number 1, block BB, that has been cancelled, and alternative plot number 10 at block BD is being, my lord, allotted. Subsequently, my lord, page 45, your lordship will get, my lord, the another, rather, my lord, page 47, the fresh agreement was being executed, my lord, for 99 years. My lord, in respect of, my lord, schedule, my lord would get at page 50. This is, my lord, the new plot number 10. My lord, two clauses are important. Kindly, my lord, comes back to page 48. My lord, this is the agreement, my lord, the deed. Kindly see clause number, my lord, 2III.
Yes.
This is important. At the own cost of the lessee within 5 years from the date hereof, or within such further time as the authority may its option allow in writing, on sufficient and reasonable grounds, to erect, construct, and complete a house or building on the demised land for being used for residential purpose with boundary walls, sewerage, and drains in accordance with the plan, sanction, and specification as may be approved by the appropriate body according to the rules and regulation framed in this for the purpose. So, the time bound, the time limit is prescribed as 5 years, and the authority is retaining the power of extension of time on certain grounds. But as your lordship are having under section 5 of the Limitation Act, yes, the court is can extend the time provided I can satisfy the. Kindly turns over the page, kindly looks at page clause 4I, page 49.
Yes.
If there be any breach or of any covenant on the lessee's part herein contained and to be performed or observed, or any of the terms and condition hereof, then in the said case it shall be lawful for the authority at any time thereafter to re-enter upon the demised land or any part thereof in respect of the breach of the lessee's covenant herein contained. So, they want to invoke this clause, because that is one of the covenant of the agreement I have shown before your lordship, 2III, wherein it has been stated the authorities granted a time limit of 5 years, and they are retaining the power to extend the time in a proper case upon satisfaction of the grounds. Praying for extension. Now, kindly now takes up page 54 of my lord's brief. In respect of such allotment, the possession was handed over to the present petitioner. The possession certificate your lordship will get on 2nd of January 2003.
Yes.
Right. Now, my lord, kindly turns over the page to page 56.
Yes.
7th of January 2019, my lord, the authority is writing to my client. It is seen that plot number 10, my lord, I have shown the details, which was leased out to you on 19th December 2002, has kept vacant till date. As per clause 21B3 of the lease deed, you were supposed to construct the resident house at the said plot within 5 years. You are thus asked to show cause. Kindly, my lord, marks this as to why your allotment will not be cancelled as per clause 4I of the said lease deed. Your letter must reach to us within 10 days to issuing the letter, failing which your allotment will be cancelled without further intimation. So, authority is known that yes, the authority is having or retaining the power of extension, and this is one of the violation as enumerated in the covenant, So they are giving a show cause notice to me. I have to answer within 10 days. So they will decide whether they will exercise their power of extension or not. Otherwise, my allotment will be cancelled. This is sum and substance of the letter. Kindly turns over the page. This is 7th of January 2009. My reply to the show cause is 16th of January 2009. Next page, Milord. What I have written.
Yes.
But may I place before the lodge? That I was given possession of the plot more than a decade after original confirmation and many years after original allotment of plot. Not since in the meantime, the cancellation of the original plot and thereafter. That it was given original allotment to the different plot, but even after documentation, this original plot was not given possession to me by the KMDA. That even after the allotment of alternative plot, actual possession was delayed substantially. That when the plot was applied and original allotment given, I was working in Kolkata. However, after about 13 years of confirmation of lottery result, when the possession of the alternative plot was given, my place of work had shifted from Kolkata to other place, including Delhi and currently Mumbai. That my current job involves working in nationally important assignment and requires frequent trips abroad. That with the above in view, it is not been possible for me to start building activities, though once I submitted building plan to the concerned corporation office. That because of my duties outside Kolkata, nature of job and its pressure, and traveling and outside India, it would be extremely difficult for me to start construction activity immediately. That as such, I request you to kindly extend the construction validity period by at least 3 years, enabling me to start construction in due course. But this is my explanation to the show cause. But I will not trouble your lordship by placing the same thing once after other, because there are several representation. Kindly takes up thereafter page 60. The operating portion, my lord, I shall place from page 61. My lord, the 2 paragraph of page 61, nearing the middle, my lord, based on the above. Has your lordship got it, my lord? I have been pursuing the office at the administrative officer of estate manager such and such KMDA for last 8 months to pay the land rent. However, despite of several letters and visit to your concerned office, I have neither received detail of the land rent dues to pay, allowing me to pay the land rent, nor your concerned office has provided me any reasons why such details cannot be given, allowing me to pay the land rent. With the due respect of your concerned office, I must mention that its action has really put me in bind. On one hand, the above referred office has served me a notice for delay in construction, but on the other hand, the same office is not allowing me to pay the land rent, which is prerequisite to get my building plan passed and starting the construction. I am sure such delay in the concerned office are also resulting the loss of revenue for the government. So, my lord, when my show cause notice was not there, I replied to the show cause. When that was under consideration, I also tried to pay the ground rent, so that this is prerequisite. If I cannot pay the all revenues of the all avenues, the concerned corporation authority will not allow me to even pursue to my sanction plan. So this was there. Kindly takes up, turns over the page. The next page is the hearing notice that was given on 15th of September 2010. Yes. Asking me to appear on 24th of September 2010, 3:30. Kindly now takes up the cancellation order that is impugned before your lordship at page 66 of my lord's brief. The memorandum dated 7th of February 2011. Now, I will, prior to placing of this, if the agreement, it's a bilateral agreement. If the agreement suggests, yes, this is the time limit and the authority can extend it, and the violation of one of the covenants gives them power to take possession, they have issued a show cause notice within their conscious mind that yes, we are retaining the power of extension. I have given my answer to the show cause that was pending. Everything communication made. Now, what is the authority, whether they have exercised anything within their wisdom, because they are a quasi-judicial authority as of now, because they are deciding something. While referring the above, this is to inform you that HIG plot number such and such was allotted, this is the petitioner's name. After actual measurement of plot number such and such, under measurement such and such, the possession of the land was delivered to you. According to the terms and condition of the lease deed executed with you on 19th of December 2002, the allottee had to complete the construction of the residential house within 5 years from the date of execution of the lease deed. That is within December 2007. Pausing here for a moment, Lord, the possession was delivered to me in sometime 2003. But it is found that you have kept the plot vacant beyond the period stipulated in the lease deed. This is clearly against the terms and condition of the lease deed executed by you. Therefore, as per the terms and condition enumerated in the lease deed, the allotment of plot number such and such is hereby cancelled and possession of the land is delivered, withdrawn. Lease deed executed does stand cancelled. Lord, pausing here for a moment, may I ask this question to myself? Where is, Lord, the consideration? You have issued a show cause. I have given my reply to the show cause. The agreement suggests you are retaining the power for not extend the time. Whether my explanation is not justified, not reasonable, not a bona fide one, some little bit of exercise of discretion. Had it been a case that straight away this can be cancelled, why is they are issuing show cause to us? May I ask this question to myself? Once the show cause is being issued, they are retaining the power of extension. I have given my show cause explanation provided. Initial allotment sometime in 90s, you have cancelled by your own. Ultimately 2002 final allotment, execution of deed. Thereafter 2003, you have given me the possession of the plot in question. When I was participated in the lottery, then I was posted in Kolkata. The scenario has changed. I prayed for extension of time. You do have retaining the power for extension, but nothing is being spelled out. But this cannot be a consideration. On merits, they have not given nothing. Not even spelled out what is my explanation about and why it is not bona fide, as per them. And thereafter, after cancellation, I have given certain representations, ultimately this writ petition. This is my submission. This is something, a jurisdiction vested with the authority, but clearly not exercise of that jurisdiction.
Your request for reconsideration was also not considered.
This cancellation stands. That's why, I have challenged this cancellation by filing the present writ petition. That is my prayer in the writ petition.
That's all your submission. Next week. Will you come back?
Your Lordship, because some decisions, my lord, I would like to cite, but today, if your Lordship so desire, my lord, on facts, I can make some.
So let me release the other matters for the day.
Because today the difficulty is I have not brought all these judgments because
your submissions on
facts.
Yes,
on facts I can.
Next day.
Next day I should.
Short matter.
Yes.
Other matters release.
The subject matter of challenge in this writ petition is the cancellation of allotment. The power or authority in exercise of which the cancellation was done by the authority. It derives from a contract being the lease deed, which is a pure and simple bilateral contract having no public law element involved. My first submission would be that can be adjudicated, that cannot be adjudicated in a writ jurisdiction. There are decisions. And this can be decided by a competent civil court upon laying of evidence, as he has disputed facts. If your Lordship kindly, some documents my learned friend has already cited, even then, my lord, first, the allotment was made in 1993. The possession could not be handed over because of some legal complications. Then we cancelled that allotment and a fresh allotment was made, and following which, my lord, a lease deed was executed. He was asked to accept the alternative plot of land. He accepted, and then, my lord, a lease deed was executed. That what my learned friend has referred to starts from page 47.
Yes.
Here at clause page 48, 2 Roman 3 says that at the cost of the lessee within 5 years from the date hereof or within such further time as the authority may at its option allow in writing on sufficient and reasonable grounds to erect, construct, complete a house and so and so. Here, the lessee was obliged to make construction within 5 years or within such time as may be allowed by the authority on his prayer on reasonable, sufficient or reasonable grounds. Admitted, and there is a at page 49, you will find at 4.1, the consequence of breach is there, and my learned friend was referring to clause 3 that any relaxation that doesn't go in favor of the petitioner, that is in respect of both the parties, that any relaxation or indulgence granted by either of the party to the contract, that will not prejudice the rights of the parties. So, my lord, admittedly, this lease deed was executed on 19 December 2002. So, as per clause 2.3, within 5 years, the lessee was supposed to, my lord, obliged to make construction within December 2007, within 5 years. Admittedly, my lord, the lessee could not make any construction, neither make any construction, nor the lessee had prayed for any extension of time within the stipulated period or beyond that. Then, my lord, a show cause notice was issued, that is at page 56 of the writ petition.
Extension was prayed for the first time in reply to the show cause notice.
In reply to the show cause notice, not before. So, in reply to the show cause notice, my lord, he has cited the reasons according to him. And then some letters were written. Then the authority called for a hearing. That is at page 62. This was referred to by my learned friend also. Hearing was conducted. One page my learned friend has not placed. The next page, page 63.
65.
63. 62 is the hearing notice. He was asked to attend the hearing and he attended the hearing. And 63 is the findings made by the hearing officer. And he attended, the lessee attended the hearing, and the endorsement lordship will find the below, it is in his own handwriting. It is not that his reasons were, whatever reasons were given or extended, the explanation offered, they were considered by the authority. An authority reached a decision that the allotment is liable for cancellation. And following this, my lord, page 66 was issued. Thereafter, the cancellation order was issued. That is at page 66, which is under challenge in the instant writ petition. In the cancellation order, lordship will find the last line of the amount paid will be refunded after deduction of 20% as the service charge. Lord, after this cancellation of allotment, the money was refunded to him, but the lessee did not accept that, refused to accept that. Even we have tried in our writ petition, we have explained, Lordship, kindly take up my affidavit.
Has the representation been considered in the cancellation order?
Against the cancellation order, there is no scope to consider the representation.
Show cause was issued, a reply
Show
was
cause-
filed,
Reply was filed,
and the
hearing
reply-
conducted.
there should be a consideration of the reply, why it is accepted, why not. That is not in that order, cancellation.
No, that is what page 63 says.
Yes, your affidavit.
Yes.
My reply was not filed, but
My lord, Lordship will find from B that what I have. This is the facts I have narrated, my lord, as a sequence, my lord, 93. For B also, my lord, since the possession was not, could not be handed over, then alternative plot of land was issued. Then lease deed was executed, the provision of which I have placed, my lord. Then, my lord, Lordship, kindly come to page 6E, that may I read this para. Despite such specific covenant in the lease deeds, page 6, para E, for E. Despite such specific covenant in the said lease deed, the allotee being the petitioner herein failed to commence and complete the construction of a residential building on the demised land within the stipulated period of 5 years from the date of execution of the lease deed, or even thereafter till 2009, no prayer for extension was made by the petitioner to the authority on any ground whatsoever. Such failure and a breach of the terms of the lease deed on the part of the allotee being the petitioner herein itself warrants cancellation of the allotment vis-a-vis the lease deed in terms of clause 4(1) of the lease deed. Pausing here for a moment. The lease deed provides the consequence of breach. The breach committed long before 2009. Within the stipulated period, the 5 years, the allotee, if the allotee prays for extension of time for any reason, he may be prevented by any other reason. Then the question of the extension the authority can consider. Here in the present case, there was no prayer for extension. Till 2009, the show cause notice was issued. The answering respondent authority then issued a show cause notice to the petitioner on 7 January 2009, asking thereby to show cause, because in January 2009, Lordship will kindly visualize this position, since there was no prayer for extension of time on any ground whatsoever, then for violation of clause 2 Roman 3, the consequence provided in 4(1) must be ensured. So, observing the principles of natural justice, my lord, it deserves to be notified. That is what the notice was issued. He cannot, even after the show cause notice, even, my lord, for the sake of argument, my lord, whatever ground he has shown, but the breach committed prior to that, the consequence must be ensured as provided in the contract itself. He cannot say, no, within such a time, I have prayed, you have not considered. This is not the fact. So the case the petitioner is trying to make out, that is beyond the scope of the. This doesn't come. It is absolutely up to the authority. But the contract, the parties, when they have entered into a contract, the parties to the contract are bound by the terms of the contract. And by the terms of the, if the parties go by the terms of the contract, there is no scope. Absolutely, there was no scope. So for the purpose of cancellation, why? Because the 4(1) must be ensured. So he was notified. So why it should not be cancelled? Reply yes. Then he replied and prayed for further extension. In response to the said notice dated, the petitioner submitted reply. My lord, here I have not completed the sentence. The answering respondent authority therefore issued a show cause notice to the petitioner by memo number so and so dated 7th January 2009, asking thereby to show cause within 10 days from the day 10 days of issue of the notice as to why the allotment in question shall not be cancelled as per 4.1 of the lease deed. In response to the said notice dated 7th January 2009, the petitioner submitted his reply dated 16th January and also prayed for extension. Here in reply, for the first time, he has prayed for extension of time. I have written also there for the first time, at least 3 years to complete the construction. Then, my lord, we conducted the hearing, that is, my lord, the petitioner attended the hearing, offered explanation once again about the reason for non-construction on the demised land and also paid for extension of time. The petitioner was heard and he has endorsed his submission in the order dated so and so, what is shown at page 63 of the writ petition. He has himself written in his own handwriting. If the authority was, however, not satisfied with the explanation offered by the petitioner for non-construction on the demised land within the time stipulated in the lease deed and decided to proceed strictly in terms of the lease deed, inasmuch as in terms of the clause 4.1, the allotment is liable to be cancelled for violation of 2.3 thereof. Accordingly, with a memo number so and so 7th February 2002, the special secretary addressed to the intimating that as per the terms and condition, the lease deed was cancelled. Thereafter, my lord, the father of the petitioner made a representation on behalf of his son, that is being the LOT, that is, I have stated. This is not the representation of the petitioner, but his father. And pursuant to the cancellation, my lord, the land was resumed already. And thereafter, lordship will find in para I, J, we tried to refund the amount. It was repeatedly sent, but the petitioner did not accept. So this is the position, and K. lordship will find what I started with the beginning of my submission. And all this in support of my contention, my lord, all these documents I have annexed with my affidavit. My lord, my respectful submission, my lord, here, I do not know whether the petitioner will press on that or not. In that, petitioner has also filed a supplementary affidavit. He has not. Press korbe? If he doesn't press, my lord, I need not make any submission on that.
What is it about?
My lord, he was trying to.
The problem is that my change brief, my advocate on record is not here. The original ta kotha?
Original is here.
Oh, blood, your lordship.
Submitted.
In the supplementary affidavit, although in the writ petition no case was tried to be made out about discrimination, in the supplementary affidavit, he has tried to make out a third case.
Discrimination between?
Because some other persons,
some other plot owners, but since they are retaining the power of extension, for this extension power they have exercised in respect of the other plot holders, but not in my case.
that is what sought to be. This, first of all, my lord, this cannot be done. My lord knows that it goes against the settled principles of Brahmada's case. By way of this gives a fresh cause of action. But this cannot be done by way of any affidavit or by way of any misapplication. That is the case.
Not to say that the petitioner has to demonstrate that they are similarly circumstanced.
Not in the writ petition. Not in the writ petition. This is altogether a new fact. He has tried to brought, my lord, which cannot be done because it is the settled position of law, my lord knows that in Brahmada's case, that one cannot improve by way of a supplementary affidavit or mispetition. That case should have been made in the main petition itself. In the writ petition, there is not a single whisper about the discrimination. So this case, my lord, cannot be done. The supplementary affidavit, the contentions made in the supplementary affidavit, the court cannot take cognizance of. Because it goes against the settled principles of law. Supplementary affidavit could have been, my lord, entertained. It can be entertained by the court if something, my lord, in connection with not altogether different. Here the thing he has tried to brought in is altogether new thing. The case of Article 14 has not been built in the writ petition. So by way of supplementary affidavit, he cannot. My lord, if necessary, my lord, I'll be referring to the Brahmada's case, that is the settled principles. Till date, that is holding the field. My learned friend also knows that. My lord, on the other day, my lord, my lord, this issue is no more res integra, my lord. My lord had occasion to deal with this identical issue, had decided, and that is being affirmed up to the Supreme Court. And
Please take instructions. Please go through this.
Milord,
Learned counsel says that this is no longer res integra.
Milord, regarding the extension, Milord, what
regarding cancellation, exercise of power of cancellation.
Milord, regarding the cancellation exercise of power, my learned senior friends say this has become, Milord, the binding precedent. The Honorable Supreme Court has made it clear. Milord, let my learned friends show. Milord, it changes, Milord, from case to case. Here, Milord, what my lord has suggested, Milord, I will have to demonstrate, Milord, the discrimination in such a way that it is similarly circumstances. If I can able to show even, Milord, my case is, Milord, far better than the case, Milord, that has been, Milord, extended. 8 years delay has been, Milord, extended by payment of cost. So, Milord, the authority, they cannot also discriminate. Milord, your lordship knows in a civil jurisprudence, the discrimination cannot stand. But in a, Milord, service or this kind of authority cannot discriminate, Milord, in one allottee. He can say, for your delay, 8 years, I can condone by payment of cost. But for your delay for 1 year, I will not exercise.
Had it been a case,
Decision,
yes,
it is not part of the
read.
Milord,
Yes.
that for supplementary affidavit, if my learned friend is suggesting that a memorandum I have challenged, Milord, one of the ground of challenge or one, Milord, some, Milord, reliance in respect of some document which I have not placed in the original writ petition, I can Milord, satisfy your lordship by way of supplementary affidavit. I am not, Milord, changing any texture of my, Milord, writ petition. Texture of my writ petition, Milord, challenging the, Milord, memorandum.
Let my learned friend satisfy the Honorable Court that by way of a supplementary affidavit, he can brought in a new
ground has been brought.
Yes,
which has
Milord,
not
I
been,
am not changing the texture of my writ
Yes.
petition. The challenge to the writ, Milord, memorandum still remains. Yes, one of the additional ground I can, whether, Milord, I can, Milord, place it, Milord, I can satisfy.
I never said that you cannot take that point and are, but not in
Milord,
by
that
way of
will not
supplementary.
create a further, Milord, complication. I can come back with order 6 rule 17, your lordship. No, it's a original pleading, writ petition before your lordship. It's a original courts of fact. I can come back with order 6, but I shall try to satisfy, Milord, by way of supplementary affidavit. I can. This is an additional ground.
Her learned counsels for the parties, paragraph, that the matter will be under the same heading for further consideration. 15th May.
15th. Fine. That also contradicts his own case made out in the writ petition.
Conclude on the next.
Yes, yes, Milord, I shall come prepared, Milord.
We're almost done.
Fine,
with it.
fine. Grateful.
আজকে ভাবছিলাম আমি পড়িনি টড়িনি কিছু